Matter is not listed on lordship for my lord. The fresh submission, my lord. 2023 contempt.
Contempt.
Your lordship.
My pardon, madam. The order of this
Give us
comply in terms of the direction.
complied with.
Yes, not comply. Not in terms of the direction.
Please give you all your steps. The cases shall be listed.
This is an widow lady who is not yet their pensionary benefit, as well. Even if the honorable court orders can't WBC, don't you want?
I'll say, give your step.
Thank you for.
Several mentioned it is not been listed.
Contempt matters have been listed.
Don't matter, madam. Just two old age people, madam, in custody since 3 months, madam. They're more than 65 years age, madam.
So whether any case below your case has been listed?
No, madam, it has not been listed. I have been mentioning, madam, on several occasions.
I will pardon your
I
lordship.
will consider, madam.
I will pardon your lordship. Bail matter, your lordship, specifically adjourned to 4th of November.
All right, give.
Pardon, madam. First contempt. Saturday has not been listed for the last 4 years, despite that.
Pardon to mention, my lord, item 107 can it be taken up today? 107.
I'll try.
Modification of
Whose order? Modification of whose order?
the contempt order. The case number is wrong in type. One tender matter, my lord.
Not here. Monday. Make a mention on Monday. Not now.
Monday.
Well, make a Monday mention colleagues.
Division may make a mention before division bench.
Supplemental list to be mentioned item number 1.
Copy not served in this case on us.
Compliance affidavit on 27/11, the order has been complied. Only for the petitioner has to submit some certain document.
Complied with.
Liberty.
Item number 2.
Already complied, man.
22/11 order kind of a glance. For a moment. 22/11 order kind of a glance.
Item 2 already complied.
And yesterday evening, I contacted the client, cleared the order. Nothing has been given the benefit to.
I am giving you the copy. Yes,
The content of the key.
already complied.
So, I pray next week, yesterday evening, I contacted the client, but order has not been complied. Now they have given a letter to me. I have to contact it, so I pray you ask me to put it next week.
Where is the order?
Page 21, kind of a glance. Page 21, paragraph 12. In the result, the writ petition is allowed. The impugned order on the annexed 14 is quashed. The opposite party authorities are directed to issue a fresh order granting promotion to the petition to the post of Sub-Inspector of Police as per the recommendation of the Central Selection Board 2008, with respect on the rate his immediate juniors are promoted. Further, the petition shall be paid the area salary.
Area has already been paid. There is a credit to the area and you have to draw it, my lord. Last day. A sum would be 86,291. Only towards area salary in the rank of state police are already been drawn and credited to his bank account number so and so. Why this of bill number so and so dated 26/7/24.
They have been implemented, Mr.
So, next week, you'll also next Friday.
I'll give you liberty.
Madam.
to comply with. Yes. Of the petitioners shall have the liberty to raise his grievance, if any, before appropriate forum, if according to him. The same has not been fully redressed.
Liberty,
That liberty applied with, then liberty.
Item number 3.
Don't see your lordship, can you see the last order? Last order, 8/11.
I'm not on 21/6/24. I have already government issued also for compliance of the order. Let it come 1 week after.
Only letter has been issued. The lordship directed for compliance if not present. personal affairs, but only a letter has been issued to on 21/11.
What is TE and SCERT? Why has he not come?
Hello.
Where is he, the director?
I want a 1 week time, my lord.
No, he was required to be personally present. If by that date the petitioner is not paid the amount which he is entitled to, ask him to be here at 2 p.m. Otherwise, I will issue warrant.
My lord,
Otherwise, I will issue warrant. He was required to be personally present here.
he has not come. Let it come 1 week.
Sorry, I cannot ignore the court's order.
But at 2 o'clock I am coming, my lord.
All right. The London AGA, London Government Advocate, appearing for the contemners, seeks further adjournment. First off, he does not have instructions as to whether the court's order has been complied with or not. First off, on the last date, when the matter was taken up on previously, when the matter was taken up on 8/11/2024, following order was passed. Quote for paragraph 3. The director, what is TE? TE means what?
Technical education.
The director TE and SCRT Visa is not personally present in court. There is no application filed on his behalf seeking exemption from his personal appearance. In such circumstance, the court has no other option but to issue a warrant of arrest. Let the warrant of arrest against the director TESCRT Odisha. Let the superintendent of police, which place? Bhubaneswar, ensure production of the director TESRT on next Friday. Yes,
Item number 4.
complied.
One liberty may granted.
Liberty.
Liberty may granted.
All right, Liberty. Yes.
Item 5.
The detail is pending, my lord. Detail 4, 8, 9 and 52.
Critical pending.
Item 6.
4895 retopil. Retopil, the computer does not show, my lord, any filing of retopil.
No, vehicle number is there.
Number I have given.
That is the number or the number? What is that number?
Number. W4895024.
Retopil cannot be 4895, so 4000.
That may be D number. I will find.
Even if it's till date, my lord, the retopil has not been numbered.
Yes. This is D. And detail number is there.
Number is that is D number. Filing number. If it's not, retopil has not yet been numbered.
When counsel appearing on behalf of the contemner states that a writ appeal has been filed against the order violation of it has been challenged. So shortly this matter on. Next.
Personal affairs to director of this.
Next week. So as to enable him to permit the number of the writ appeal. Next week.
May I pray, my lord, in the meantime, some another person has joined in the post of director.
You can file an application.
I will file in petition for it.
The personal attendance of, who is he? Who is he? What is your position? What post do you hold?
Director, sir, higher education, I have joined just 1 month back. And
In which matter? Item number
item
five.
5.
Stands with for the present. But your appeal has not been filed. It's an only diary number. That is not an appeal.
I may be permitted to correct the cost title manner.
Not now. You file an application
To add him as a party man.
to add whosoever has joined.
I will add him.
This is up to you. We will take up the matter next week.
Oblige.
Dispense with.
Item number 6.
Already complied on 28/11, man.
Compliant. Yes.
Item number 7.
7, my lord, already complied. Demarcation was directed, we have already demarcated and demolished,
Compliant.
evicted the enclosure.
Yes.
Item number 8.
Thereafter, 18/11/54, narration of the issue, release the pensionary benefit,
Action
release
to
the pensionary benefits. That has not been complied. I have filed first content. Time they have taken to comply. Thereafter, lordship passed on. Order.
all right, yes.
As per last order, we have filed for the show cause affidavit, wherein arrears have already been paid at cash 5 and papers are already submitted to the Accountant General's office.
When?
It was submitted on 18/11/2024.
Then you will have to ensure that it is expedited.
Yes, ma'am. As per last order, done it 80 is online. Done it 80 is online.
Yes.
I am there. So far, this death cum retirement benefits and other pensionary benefits, I have already discussed with the Chief Secretary and the other officers. I am also issuing a letter today to all the officers concerned, to the district administration including, so to ensure that those orders are promptly complied with. I had a oral telephonic discussion day before. So we are ensuring that all those pensionary matters would be expeditiously disposed of, because some information we may seek for from different district administrations. So that would be, Milord, I am ensuring that all those cases would be expeditiously addressed. And so far 8 is concerned, Milord, it has already been complied with. This Prashant Samal.
No, it has not been complied with. It has been sent to the office of the Accountant General. Now
That's correct. That is not under our jurisdiction. That is the
not your jurisdiction, but you will have to have some coordination. Because see, the order was passed when?
16/11/2022.
16/11/2023.
That we will ensure. I have already directed them that they would personally coordinate with the office of the Accountant General Odisha.
Technically speaking, the order has already been violated. Contempt has been committed. So we can proceed against the officers. But since your officers have taken some action, that too very recently, we are adjourning. I am adjourning the matter for 2 weeks. But in the meanwhile, you please ask your officers to use their good offices to ensure that the AG issue the authority slip.
We will.
Otherwise,
I'll certainly will not look into it.
In the light of the court's observation, 8/11/2024, the learned Advocate General has addressed this court concerning pending contempt matters which relate to non-payment of death cum retiral dues and arrears of salary. First off, he has stated that he has already discussed the issue with topmost officials of the state government. In this regard, first off, he has assured this court that prompt action shall be taken by the state officials to ensure that all orders of this court relating to payment of pension and other death cum retirement dues are promptly complied with if there is complied with, unless there is some genuine legal hurdle. Yes. Just a minute. In the present case, it has been stated on behalf of the opposite parties that arrears have been paid.
Yes, my lords,
That-
para 5,
That
as per 6 commission, what amount?
Arrears with regard to provisional pension. Arrear with regard to provisional pension.
Unutilized leave salary has also been paid, my lords.
arrears of salary and salary equivalent to unutilized earned leave has already been paid to the petitioner. So stop. The petitioner is getting provisional pension. Stop. The final pension has already, final pension and payment of final pension and
Pension
gratuity
papers, yes, my lords, are
has
submitted.
already been sanctioned. And the papers have been forwarded to the office of the Accountant General for issuance of authority slip. So stop. What should I do? Should I drop it or wait?
We'll let it be dropped, Miller, because we'll pursue it. Now nothing remains so far. We have we'll ensure with the Accountant General Office. So for the
Since this court's order has been substantially complied with, I am of the opinion that no case of intentional disobedience of this court's order is met out. The contempt proceeding is dropped. So stop. Next. This is, however, with a liberty to the petitioner that in case the pension, in case the necessary authority slips are not issued within 4 weeks from today, the petitioner shall, the petitioner may make a mention whereafter the court shall consider reviving the present contempt proceeding.
so far, not so far we have conscience. So far the Accountant General.
No, you will have to pursue because
will
Mr.
pursue.
Acharya, I am convinced that the order has been violated. So
I'll personally look into it.
therefore, ask your officers 4 weeks enough time.
Mr. Padhi is there, Milord. Let him be directed to.
Padhi, Mr. Padhi, your party.
Mr. Padhi represents the AG.
Mr. Padhi, are you party? Are you a party in this proceeding? Please unmute. All right.
One by lordship on 16/11/2022, direction was issued to during pendency of the requirement proceeding. 1 lakh will be deducted because proceeding was with regard to the dereliction of duty and recovery. Now the department proceeding is concluded, there is no recovery.
All right.
Now they have deducted 1 lakh from my gratuity.
That you can challenge. You can the petitioner shall also be at liberty to raise his grievance in relation to remaining dues, if any.
Item 9.
Item 9, my lord, complied with.
My lord, item 9.
Complied.
Lordship kindly have a glance to the order portion at page 30.
Yes.
The second paragraph.
13,
Page 13. Second paragraph, just 4 lines before. The Tahsildar Sadar Baleshwar is directed to issue mutated ROR in favor of the petitioners as per his own order dated 16 December 1996, passed in mutation case number 3116 of 1995 within a period of 4 months. So, Lordship kindly have a glance to the order in the mutation case. That is the scheduled land.
See, Mr. According to you, the order has not been complied with.
I am saying that in the order,
Say in
clear
one
that
sentence,
Isam of the land is Sarada 2. But in the ROR, your lordship, I have given.
You can challenge that, I'll give you liberty. You can challenge that. If that order is not correct, you can challenge. The order, the decision has been taken.
In the order of the Tahsil, it is clear that Sarada true, but in the Kisam of the land. But in the ROR, they have said that Gamyo Jungle.
Then challenge.
That is the only they have to rectify.
Then you can approach, complied with current counsel appearing on behalf of the petitioner, however submitted, that there is some defect in the ROR which has been issued. The issued by Justice,
Not in accordance with the mutation case.
which is not in accordance with the order passed in the mutation case. The petitioner shall be at liberty to approach appropriate authority for a rectification. Yes.
Item number 10.
Yes, my lord.
10, my lord.
Your lordship, can see last order, your lordship's order. Can see your lordship last order. Order dated 18/11/2021.
Yes. I remember the order by seeing your face, if that is the case.
Several cases were disposed of, and my learned friend's client, he filed another case saying that it is covered by that order. That was the order was passed. He's the other man's client, whose case was stated to be covered, he got the benefit. These people, they have not got the benefit. That is the argument.
Yes.
That is why your lordship held that, yes, I feel there is a contempt. Distinguishing feature is the person who got the benefit, he was in an approved COVID hospital.
Approved?
COVID hospital. The other petitioners, they were not in the approved COVID hospital. That is why this is a distinguishing feature that has not been given. And in those cases, writ appeals have been filed. Numbers right now, the assistant director.
To file your so-called reply.
Yes.
In that context, that the petitioner as well as those persons orders was implemented, they are both are you to kindly see the
They have a right to reply. So let them reply.
that is those are completed from one institution. That is Sikha Anusandhan. That is not government
May be
registration.
correct.
This is the certificate both.
Please appreciate you have filed a contempt application. You are alleging disobedience. They are disputing it. Whether they have a right to reply or not.
Yes, ma'am.
Let them reply.
Ma'am.
Not disposing of your contempt.
Yes, ma'am. Yes.
4 weeks' time is allowed for the contenders to file a so-called reply.
All are same.
Item 11.
Item 11. Item 11, your lordship will find the order as an actual one at page 15 now.
Yes, complied with.
Passed off.
Yes, Mr. Complied with. Complied with. Also for the petitioner states.
Item 12.
That is your lordships, the order has not been complied with, where there was a specific direction to work out the promotion policy, because there is a total non-consideration of.
Let us see the order chart.
Order page 18, 13, paragraph 13, 14, 15, 16, I am relying upon.
Page?
Here, page number 18.
Page 18, yes.
Yes. Your lordship.
What is the direction?
Paragraph. Furthermore, well, here there is a total non-consideration for promotion.
Let us see the order first.
Furthermore, numerous judgments have consistently affirmed that if an individual meets the prescribed merit criteria, there is no justification for preventing them from recruited or promoted to unreserved positions. The relaxations provided are solely to ensure that reserved category candidates have a level playing field, which, along with the intent of Article 16(4) of the Indian Constitution. Upon scrutinizing the aforementioned facts in conjunction with the judicial precedents, it can be conclusively inferred that the clarification issued by the Revenue and Disaster Management Department, Government of Orissa on 11/1/2019 is devoid of legal soundness. the denial of promotion on the premise that there exists an excess number of reserved category candidates represents a profoundly erroneous interpretation of the prevailing laws and inflicts egregious injustice upon meritorious candidates from the reserved category. In the present case, the petitioner, having completed 5 years of service as an OMIN and successfully passed the requisite departmental examination in accordance with ODRS rules, is unequivocally eligible to be considered for promotion to the post of RI, Revenue Inspector. Denying him promotion solely on this basis of his reserved category status constitutes a violation of his right to equality enshrined under Article 14,
Yes.
16 of the Constitution of India.
Why will you deny promotion on the ground that he is a reserve category candidate?
I understand that. So, give me 1 week or 2 time.
2 weeks time, list this matter on 2 weeks. Stop in the meanwhile. Let the order of this court dated 24/7/2024, violation of which has been alleged in the present contempt application, be complied with, within which the court shall have no other option but to proceed against the contemners.
Item 13.
Item 13, your lordship will find order at page 8. For 11th portion, your lordship will find at page 9. Last paragraph. So advice and make representation before the appropriate authority and convening copy sought to be relied upon.
Yes.
Your lordship,
What happened to the representation?
your lordship will grant me 1 week time. I'll take instruction.
They have, from the beginning, they are saying that order has been complied. For the 2 cases, they are submitting that orders have been complied. But I will kindly have a glance to my affidavit, my objection affidavit. I am submitting that to their counter, compliance affidavit.
Who has,
Paragraph 2, my lord.
who was directed?
My lord.
Who was directed to comply with the order?
Opposite party 3, my lord, will comply with order.
Who is the opposite party member?
Srimati Pratibha Manjari Das, my lord. DEO, District Education Officer.
DEO Jagatsinghpur.
The order of this court dated 14/12. The simple order of this court dated 14/12/2021, requiring the district education officer. Which district? Which district?
Jagatsinghpur district.
Jagatsinghpur has admittedly not been, it has not been complied with.
My lord, actually, I should be truthful. Some portion of the file is missing. That is why what my learned friend said, that objection he has filed. It is not available here. That is why I was seeking 1 week.
Have not been complied with. So stop. Let DEO Jagatsinghpur be personally present in court on next Friday to explain as to why contempt proceeding be not initiated, and the person who has violated the court's order be not duly punished.
I hope by next week it will be implemented.
Let him be here.
I hope.
Item 14.
Compliance affidavit filed.
Complied with. Yes,
Item 15.
Complied, my lord.
complied. Give him.
I
Item 16.
my lord.
Yeah, please, your lordship. Now, in the last occasion, your lordship has directed the state council to take instructions.
1 week time. 1 or 2.
Where is the order?
Order is at page.
Annex 2,
10,
page number
ma'am.
10.
This is 277 of 2024.
Yes, my lord. It's already much delayed.
Item number 2016.
16, man.
Why are you not complying with the orders?
1 week time you will also be done. I'll try to see that the order is complied.
Let's this matter on next week. Stop. If in the meanwhile, the opposite parties fail to comply with the court's order, comma, the subcollector Dharmaghat shall be required to be personally present in court.
Item 17.
My lord, if not complied with.
It's not complete. Yes, that we have mentioned. That I have mentioned. Yes.
Item 17.
I have received some instruction. You have also next week by the time I will like.
As requested on behalf of the opposite party, let's this matter next week.
Item 18.
Well, in this case, I have received instruction where the order has been complied with. I file an affidavit saying that order has been complied.
If the order has been complied, what was the order?
Order is page 9. Kindly turn to page 9. Order,
There was a passage which was used by the petitioner along with the other villagers.
Just a minute. What was the order?
21/4/2023
2023.
at page 7, annexure 1 of the contempt petition. Page 7,
21 for
2023.
that has been complied with.
Yes, ma'am. The region order was already passed. Demarcation case initiated. Encroachment case also initiated.
I have no instruction. Yesterday, I have telephonic conversation with the petitioners. He was telling me the order was not yet been complied.
Please see the order already. I am holding. And I will file an affidavit. Lord.
Let's just matter on. Next Thursday. Before appropriate bench. It should go before division bench.
My lord.
It will go before a division bench because the order was passed by a division bench.
Next. Item 19.
May I please, Your Lord? Last occasion was directed to State Council to seek instruction regarding order dated 8/11/2023.
Yeah.
Regarding removal of encroachment, my lords, I have received no instruction received. Lordship, kindly granting 1 week more time. I will ensure compare. In the meantime, by telephonic discussion, I will. And I will also file compliance affidavit. Because you said the disposal of the differential, that's the page 9, operative portion of the order. The direction to the opposite party to consider annexure 3 into take necessary legal action. And
no, but why should I entertain this contempt application? You make an allegation against private parties.
Yes, Lordship.
Private parties were not noticed.
Actually, in this petition, there is a direct in contempt. There is a direction.
No direction. Why you? Sorry.
That's page 9. Para.
I am seeing page 9, para, everything. You file an application making an allegation that these persons have made unauthorized encroachment. All right. They were not heard. And you want them to be removed. And sorry.
Let's say as per contempt of section 2, if there is a civil direction, the judicial officer, the officer should comply the order.
All right, you can challenge this order. The present contempt application, the petitioner has raised this obedience of an order of the court dated 8/11/2023 passed in WPC number 35798 of 2023. The petitioner had approached this court making an allegation that encroachments had been made over government plots by opposite parties number 3 to 5 to the said writ application. First off, the said opposite parties were neither noticed nor they had appeared. First off, are they parties in the present contempt application?
Yes, no.
No. They have been made parties in the present contempt application also. Stop. The writ application was disposed of with a direction to take necessary legal action if the alleged encroachment made by opposite parties number 3 and to 5, say opposite parties was found. So stop. Next, in the facts and circumstances, since opposite parties number 3 to 5 were not noticed in the writ proceeding, comma, in my case, in my opinion, no case of intentional disobedience of this court's order can be said to be made out. So contempt proceeding is dropped.
Lordship,
Item,
Lordship humbly submitted that it is in this writ petition there is an order to direction of opposite party number 2 in contempt court law section 2. May I read, Lordship? Civil contempt means the willful disobedience of any judgment, decree, direction, order, or writ or other process of a court, willful breach of an undertaking given by the court.
When counsel appearing on behalf of the petitioner has submitted that inaction on the part of the contemners amounts to contempt of court, civil contempt of court within the meaning of section 2 of the Contempt of Courts Act, as the officials were required to carry out the court's order. First of, however, even in the given facts and circumstances of the case, I am not inclined to exercise the contempt jurisdiction. The contempt proceeding is stopped accordingly. Anything else?
item 20.
My lord, in this case, there is a change in incumbency of the office of the collector. New incumbent has come, only 1 week time may be granted to.
So, where is the old incumbent?
My lord,
Where is the old incumbent? New incumbent has come. So, old incumbent is to be punished.
he is only seeking 1 week time of your lordship that to comply with the order.
As requested on behalf of the opposite parties, list this matter on 1 week. So, in the meanwhile, if this court's order is not complied with, the court shall consider initiation of contempt proceeding.
Item 21.
Yes, one appeal. Application.
Compliance affidavit filed on
Affidavit has been
E-file. Already, we have filed 28/11. Yesterday only we have filed.
Item 22.
Item 22, my lord, I'm appearing through BC, my lord.
Yes.
Opposite party number 1 was directed to file compliance report, my lord, or take instructions upon compliance.
So what was the order?
My lord, the order was that the collector Kendrapada and collector Cutter both would take steps to, my lord, demarcate the plot schedule that was given in the writ petition. As over those plots, my lord, there is a festival called Melona, which takes place in the month of March. And due to non-demarcation, my lord, there were some disturbances in that area for which this honorable court had directed, my lord. My lord, the direction is in.
Compliance affidavit already filed and speaking order has already been passed. Copy has already been served.
My lord, the opposite party number 2 has passed, my lord, not 1. The opposite party number 2 has filed the compliance report.
How jointly the collector will pass, my lord? One collector has taken into consideration and passed an order.
My lord, the plots are situated over both Patak and Kendrapada. That is the reason, my lord.
Madam, whether anyone was heard when the matter was taken up?
My lord, in the district of Kendrapada, my lord, they were heard. But
Madam, whether any person was heard when the order was passed on 21/3/2023?
My lord, I'm not able to follow, my lord. Again, I'm extremely sorry, my lord.
The order was passed on 21/6/2023.
My lord.
The order was against the officials.
My lord.
Whether any affidavit was filed in that case?
My lord, not in that case, my lord. It was filed in this case after the contempt.
Therefore, after contempt, so in the writ, you are alleging disobedience of this court's order.
By one opposite party.
Yes. So, in whether any affidavit was filed in that case?
My lord, in that case, it was not filed, my lord. In this case, opposite party number 2 has filed compliance affidavit, but opposite party number 1, that is the
Sorry, I am not convinced.
My lord, the collector Katak has not taken any steps for demarcation as directed, my lord, in the writ petition.
All right.
And he has sought for instructions, my lord, in the last.
The petitioner has alleged disobedience of an order of this court dated 21/6/2023, passed in WPC number 16847 of 2023. Stop. The said writ application was filed by the petitioner seeking a direction to the opposite parties number 4 and 5 for taking steps for demarcation of
My lord, 2 and 3.
residual land being used as Milana Padia spread over 10 government plots situated within the district of Katak and
Kendrapada, my lord. Katak and
to
Kendrapada.
remove unauthorized construction and encroachment from over the same on the grounds mentioned in the writ petition. So stop. The writ petition, a compliance affidavit has been filed by
the collector Kendrapada.
By the collector Kendrapada, from which it appears that this court's order has been complied with. London Council appearing on behalf of the petitioner has submitted that there is no compliance by the district magistrate Katak. So stop. I am not inclined to proceed in the present contempt matter, alleging disobedience of this court's order dated 21/6/2023 for the reason that the said order was passed on the very first day when the matter was taken up without a matter was taken up. So stop. It will be the contempt proceeding is accordingly dropped. So stop. The petitioner shall, however, be at liberty to take recourse to appropriate provision of law for demarcation before appropriate authority.
My lord, my representation is
Item 23.
Collector Katak, my lord.
Compliance affidavit has already been filed, my lord.
Yes, complied with.
Lord, order dated 6/9/2023.
Complied with.
Item 24.
Not completed. 18/1/2023 is not completed.
Proposed affidavit we have filed, my lord. We have stated that SLP number 19403/2024 is pending.
SLP there. SLP.
Item 25.
Complied with.
Item 26.
May I please have your seat?
Yes.
My lord, order is at page 20. On last occasions, my lords queried that whether notices were issued in the writ petition to the contemner or not. That's why the writ petition record was called for. My lords, hide order dated 15/2/2026.
48%. Yes. Yes, who is appearing for the contemner?
Who key particular way?
My lords, central government.
Central government.
Central government, they said that they will not appear.
My lords, my humble submission is notice may go.
Notice will go.
My lord.
So who against whom notice should go?
My lords,
Against whom notice should go?
my lords, contemner one.
Herald al Samaria.
My lord. My
Herald
lord.
al Samaria.
My lord.
He has violated.
My lord.
He has violated the order.
My lord.
Where is your application? You were required to make an application for expeditious disposal.
My lords, my application is my lords, page 15. It starts from page 15. The
15, annexure.
annexure 3, my lord. And page 16 is the relevant application.
Come to annexure 3. When was the order of this court passed?
My lord, page 20.
When was the order of this court passed?
34/2024.
34/2024.
My lord.
So thereafter, this communication was made to you 24/5/2024.
No, communication was made. I letter dated 13/5/2024.
13/5.
My lord.
What is there?
My lord.
What communication was that?
That is the letter along with that order of this.
So thereafter, this order, the communication is made to you 24/5/2024. Come to annexure 3.
My lords, that letter itself reflects that the order of this honorable court was written without implementation. To avoid implementation, that order was written. The original envelope through which the contemptor returned the documents. That's why, my lords.
All right. Which matter was pending before the Central Information Commission?
My lords, one letter dated.
Mr. Counsel, which matter was pending before the Central Information Commission?
My lords, the writ petitioner submitted an application dated 1/9/2023. That was pending before the Honorable Commission.
Later,
No, my lords, that was a petition.
Petition?
Petition, my lord.
So you were required to file a second appeal. You could have filed second appeal.
No, my lords, against any order, appeal should have been preferred, my lord. No order has been passed.
So why did you approach CIC then?
CIC, my lords, a petition under section 4 of the Right to Information Act was filed. To dispose of that petition, writ petition was sought for.
So,
Item 27.
sorry, it's a frivolous case. Next.
27.
Dismissed.
My lord, so called affidavit has been filed where we have stated that WA number 2316/2023 is sub judice before this honorable.
Yes.
Copy it.
Writ appeal. Yes.
Item 28.
No. Lots of copy have not served.
Compliance affidavit is filed, my lord.
Give us a copy.
Also,
Yes.
I have filed objection of affidavit and 8 December, Lordship, you have ordered to serve to the show notice.
So where is the order of this court?
The new cause of action is already arrived by
Lordship, it is a mandatory suspension allowance will get to the petitioner, but very difficult to survive, Lordship.
So whether the order subsistence allowance has been paid or not?
Yes, Lordship.
Whether subsistence allowance has been paid?
Till date, Lordship, petitioner had not gotten suspension allowance for 16 months. Above 16 months, Lordship. Also, she is a anemia patient, Lordship. Also,
not the observation, the order of says, where a suspended employee shall join in his her headquarters, fixed then only the DDO concerned will calculate disburse seizure subsistence allowance. But Sanjukta Tandia
This is the
JRA
invalid lordship.
has never been joined in the headquarters, that is Burundi Tahsil, at any point of time. Hence, subsistence allowance could not be disposed in her favor. Accordingly, the representation.
Whether this has been served on her.
No, no, lordship.
Yes.
Sir, lordship, 8 December, you have ordered to so cause notice served to me, lordship, but
Compliance
still
affidavit
they have
was
not
not
served.
served. Compliance affidavit
Copy
was
of the
served.
compliance affidavit is served upon land counsel for the petitioner by Monday. This case next week. Yes.
Item 29.
Last order. My lord, is a matter relating to revised scale of pay, my lord. My instruction is that it is now being processed in the Department of Law. Next week it will be compliant.
29/9/2022 has not been complied with.
Yes. All right, let them do it.
Item 30.
Just a second. Just a minute, that's fine. Is this matter on next week so as to enable AGA to seek instructions as regards full compliance of this court's order.
Item number 30.
Order dated 10/4/2024 has not been complied with.
State is not the party.
Notice to
Notice will not go.
notice till not go. Notice.
Where is the order?
Order is annexure 1, page 11. At page 11, para 6 1. Concerning the limited nature of grievance of the petition, the petition is displayed at the stage of admission with a direction to the opposite partner 3 and 4 to consider the representation of petition under annexure 5.
So what is KFINTEC?
Pensionable organization, madam. Pensionable organization where the petitioner was working in a Gramya Bank.
Gramya Bank.
Yes, ma'am.
Gramya Bank, no notice was issued to Gramya Bank.
Notice was issued in the stage of admission, but thereafter, opposite one 3 and 4 directed to comply the order.
3 and 4, no notice was issued to anyone.
3 the Kipintech and 4 is the SDFC Bank, my lord. Only my limit of priority, notice to government. If notice go, they will give benefits. The petitioner is not getting his pension, man.
What is this KFI? This is a state.
This is a central record keeping agency, my lord.
Agency is a private thing.
But HDFC is a bank, my lord.
HDFC is also private.
They have been directed by the order.
The petitioner has alleged disobedience.
Only my limited notice to go there.
Court's order dated 10/4/2024 against opposite party number 3 and 4. Stop. Opposite party number 3 and 4 were not noticed in the writ proceeding, and the writ proceeding. So, in any view of the matter, I am not inclined to.
My lord, the petitioner is not getting his pension, my lord.
This aspect would have been decided in appropriate forum, in appropriate manner.
The total amount was deposited before keeping taking. During his service, his entire amount,
So you were where were you serving?
Odisha Gramya Bank, my lord. I am serving in Odisha Gramya Bank.
Then still you are serving.
No, I have retired. It is for pension, my lord.
So you can have a grievance against Grami Bank.
I have made grievance against Grameen Bank, but court was directed to opposite partner 3 and 4 to comply the order.
How can we realize?
Kindly see my order, my lord. 3 and 4 was directed. That's why I am making them contempt.
3 and 4 were required to be heard then.
Sir, sir, page 11, para 6, it is clearly opposite party number 3 and 4. Redirected, my lord.
And you implead gram of any officer of the Grami Bank, I'll issue notice.
I implemented, my lord.
Land counsel for the permitted to implead the officers for the Grami Bank as opposite party number, opposite party in present application. Topless this matter for weeks. Yes.
Item 31.
Item 31, as per the order dated 22nd November, complaints on the affidavit is noticed.
My lord, let's kindly turn to page 27, that is the order, my lord. It is a case where petitioner says that he purchased a land from his vendor. Now he needs to land is converted to from Jolasaya Kisam to Titiban. And he wants to ROR is to be issued. Direction was issued that ROR may be immediately published, my lord. Now what happens, my lord, if it is a land under water body Kisam, Jolasaya Kisam, it cannot be converted. I have received instruction that in the meantime, OLR appeal number 16 of 2024 is pending before the superior authority for the sub-collector Bhubaneswar. That is the impediment for which the Tahsildar is not able to issue the ROR.
My lord, after register said it in 1989, ROR has been prepared in 98, my lord.
You are alleging violation of this order, 29/11/2023.
Yes, my lord. My lord, in 2006, OLR case, in OLR Act, in OLR case number 1341 of 2006, we have already deposited the amount.
Please read the order. Please read the order.
Yes. Accordingly, the writ petition is disposed of with a direction to the Tahsildar Bhubaneswar, opposite party number 4, to publish the corrected ROR within a period of 4 months from the date of receipt of certified copy of this order, if no legal impediment is there. My lord, my case is in 2006, my lord, I have already deposited the.
See, madam, whatever you are arguing now, you could have argued when your writ petition was taken up.
Already argued, my lord.
You did not argue anything. You did not utter a single word.
Yes, my lord.
I tell you, madam, that in the writ proceeding, you did not utter a single word.
All those annexures.
Nothing, no annexure, no annexure was seen. You did not refer to any annexure. No pleading was seen. You did not refer to any pleading. Now in the contempt proceeding, you are making all those submissions.
My lord, I have already got permission from the BMC.
Madam, please see the order. Please read from paragraph 1. That's all. And now in the contempt proceeding, you want the court to decide.
After getting the holding number, after getting permission from
holding
the
number
BMC,
is mentioned. In the order, holding number is mentioned. Nothing. Therefore, we cannot adjudicate upon disputes in contempt proceeding. Contempt proceeding, our jurisdiction is limited. Whether any the petitioner has alleged disobedience of an order of this court dated 29/11/2023, which was disposed of with a direction to Tahsildar Bhubaneswar to publish corrected ROR within a period of 4 months from the date of receipt of certified copy of the order if there was no legal impediment. Stop. And counsel appearing on behalf of the AGA has submitted that matter is pending somewhere.
Before the additional district magistrate Bhubaneswar, OLR appeal case number 16 of 2024.
That an OLR appeal number
16 of 2024.
16 of 2024 is pending in respect of
Under section 58(1) of Odisha Land Reforms Act.
section 58(1) of the Odisha Land Reforms Act regarding what?
Regarding conversion of land.
Regarding conversion of land which was originally land in question, which was originally in the nature of Jalasay. Stop. Next, in such view of the matter, no compliance of the said order of this court. Okay. In no case of disobedience, this court's order dated 29/11/2023 is made out. The contempt proceeding is dropped. Yes, the petitioner shall be. I make it clear that I have not gone into the issues raised in the. We have that I have not considered the disputes which are being raised in the present contempt application, which have not been addressed in the order passed by the learned single judge. So stop. Order dated so and so, violation of which has been alleged in the present case. Stop. The petitioner shall be at liberty to raise all such issues before appropriate forum. Yes.
Item 32.
Well, permitted to withdraw with
Comply.
Yes.
For orders item number 33.
Your lordship, referral due. This is the second contempt, your lordship. Sometimes notice has been issued, and this time the noting was that he left the place without instruction. He left the place without instruction.
Without instruction, then dropping it.
No, my payments are still due. I am retired way back in 2018, your lordship.
What are you saying without instruction? Where is the order?
Order 25/9. Original order is 25/9/2019.
Where is
Direction
that?
was to consider my representation.
Where is that?
That is page 3, your lordship, of the contempt petition. I have quoted the operative person.
Quoted.
I have quoted, your lordship. And in the first contempt application, your lordship.
Forget first, second. Let me see the order.
Yes, page 3 of the contempt petition, your lordship. 25/9/2019. In view of the aforesaid limited grievance of the petitioner, without expressing any opinion on the merits of the case.
Yes, we have taken decision.
State is not a party. Noyagad Central Bank.
Noyagad Central Bank.
In the writ petition, your lordship, state was a party. And direction was made to OP number 3, Secretary, Noyagad District Central Bank. So the direction was given to OP number 3. And accordingly, I have made the contempt made in the party. And in the first contempt, your lordship kindly sees turn to page 7, your lordship. Page 7, your lordship may kindly turn to. Initially, 3 months time was given for my referral dues, payment of my referral dues. Again, 1.5 months time was given. Page 8, your lordship. It is made clear, the last portion.
Page 8.
Well,
what is that? So, in the writ petition, notice was not issued.
It was disposed of at the stage of admission.
Right. So, in the first case, notice was not issued. In the first contempt application, notice was decided not to be issued. And in the second contempt, you are saying that the contempt has been committed.
Below, my limited grievance is only for payment of my referral dues.
Limited grievance, the other side was required to be heard. How can you allege contempt? What have they done?
The direction was to consider my representation.
What have they done?
Below, they have done nothing.
They have done nothing because they were not heard.
Below, rightly or wrongly, an order has been passed.
All right.
And they have not complied. They have to communicate at least, either affirmatively or negatively, they have to comply at least.
Petitioner filed a writ petition before this court seeking certain directions. giving rise to WPT number 17666 of 2018. In the said writ application, the officials of Niagara District Central Bank Limited were impeded as parties. First off, there, however, no notice was, however, issued to the officials. First off, considering the writ application was, however, disposed of with a direction to the opposite party number 3 to take a decision on the petitioner's representation, which was brought on record by way of annexure 4 to the writ application. First off, alleging disobedience of this court's order, the petitioner filed a contempt application before this court, giving rise to CONTC number 519 of 2020. First off, the said contempt application was disposed of by an order dated 24/2/2020. First off, the said order came to be disposed of. 24/2/2020. First off, no notice was issued again to the contemners of this and contempt proceeding. First off, apparently, thus, the opposite parties were not heard in the in CONTC number 519 of 2020. Stop next. In such view of the matter, this is second contempt application which has been filed alleging disobedience of the same order of this court dated 25/9/2019, passed in WPC number 17666 of 2019. First off, in my opinion, no case of deliberate disobedience of an order can be made out against such persons who were not heard either in the writ proceeding or in the first contempt proceeding. First off, in my considered view, no case of intentional disobedience of this court's order is made out. First off, the petitioner shall, however, be at liberty to pursue his remedy before appropriate forum in accordance with law. First off, peculiar facts and circumstances of the case, it is observed that if the petitioner pursues his remedy before competent official relating to post-retirement dues, the court expects that the concerned officials shall take a sympathetic view in expeditious consideration of the petitioner's claim. First off, the petitioner shall, it goes without saying that the petition, that if the grievances are not redressed, the petitioner shall be at liberty to file a fresh writ application, as till date his rights have not been duly adjudicated upon. All right.
With the due humility, Your Lordship, the problem is that the person is now suffering from different.
I have mentioned everything. I have mentioned everything which I don't mention normally. I have mentioned that and finally, if there is any dispute, that will have to be adjudicated upon. Like filing of representation and disposal will not do. At least even for that purpose, they are required to be heard. That there is a representation you are not considering.
The precarious condition, Your Lordship, he may not come again. And that is the problem. He is in precarious condition, Your Lordship, suffering serious financial crisis.
Therefore, I have mentioned item 34 And if he, see, Mr. Counsel, if someone has any financial issue, see, you are helping him as a counsel. I'm not saying this lightly. Also, the lawyers have a duty that if someone is as financial constraint, you will be taking up his case free of cost or whatever. But now we have legal services authority at state level, the district level. If someone has any financial crisis, one can approach
That I will take.
those.
That I will take.
But always believe in getting the disputes adjudicated. Otherwise, this will happen.
Here the problem is that both the orders in the contempt application render infructuous.
See, had he been a party, the matter would have been different.
Was a party in the read petition.
No, had they been noticed,
party.
the matter would have been different. They were not noticed, they were not heard.
That is, of course, the domain of the court, your lordship. At the first hearing, the court was pleased to dispose of the matter at the stage of admission. So counsel has nothing to do with the order. Your
Counsel has to do. Counsel has to tell the court that this is a dispute, it is required to be adjudicated.
Anyway, I am obliged. I am obliged.
May I please, Your Lordship?
34.
My requisites are not accepted because I felt that I filed requisites. Maybe accept.
All right.
Item 35.
Item 35, requisites have been filed. It has to be accepted.
Same.
Item 36.
That is complied.
Complied man and liberty may be given man.
Liberty.
37.
Complied.
Already disposed of 2211, not unanimously, here has been mentioned as 23 instead of 24. That were affair.
Item 38.
Complied.
Item not 39.
As requested. On behalf of the opposite party, this matter on next Friday.
Item number 40.
Your lordship in last episode directed me to file a reply affidavit. I have already filed, it has not been tagged. So I feel it will come 1 week after by tagging the reply affidavit.
It is there. What was the direction?
Is there reply affidavit?
What was the reply is there with us, with me.
My REF, the lordship is directed to consider my REF application as per the recommendation of the government under Annexure 8 cities. Now,
Annexure
8 cities, blood.
This is 2243. Rakesh Kumar Patel.
Yes.
2243.
Yes, you are referring to which annexure?
2243, annexure of the original writ petition, blood. Lord, may kindly
Where
have a
is the
glance.
order? Let me see the order first.
I have quoted the order at page 3. Blood. Considering the liable contentions of the party and as a final decision in the matter is required to be taken by the opposite party number 4, this writ petition stands disposed of. Last, I am reading from the last portion. Blood. To finalize the issue for providing appointment to the petitioner under the Rehabilitation Assistance Scheme, keeping in view the development through the order by Annexure 8 series.
So what was the direction?
For consideration of my Rehabilitation Assistance Scheme application which was pending. There are
Before whom?
Before the collector Sambalpur.
Yes.
They have filed a so cause. I have filed a reply affidavit.
What is their stand?
That's now 2020 rules have come into the picture, and thereafter the petitioner was called for to file fresh application, but no fresh application has been submitted by the petitioner.
All right, do it.
No, Lordship, what they say is directly in directly in contravention of the orders of the Honorable Supreme Court.
Challenge that decision.
I have given in my reply affidavit.
Mr. Counsel, you can challenge that in writ proceeding, not here in contempt proceeding.
Well, what they say, they kept it pending. My father died in 2015.
Mr. Counsel, please understand that I do not have any jurisdiction.
Even they have not taken a decision on your lordship's order, my lord. Till date, what she says is in the affidavit is that her order is above your lordship's order. May I read the so-cause they have filed, my lord. What she says, lordship, may I read the so-cause reply, my lord, what she says. In her reply affidavit, she has got no regards of the orders of this honorable court, my lord. That is what, my lord, is before. Even the honorable apex court, my lord.
It's very difficult. Don't make such observations.
No, lordship. What is stated, that is what I am saying, my lord. What she states is that she is that saying something and may place the so-cause reply, my lord. So-cause reply is something different, my lord. She says what I say is has primacy over your lordship's order. May I read it?
May I say something?
No. Only I want to.
May I say something?
Yeah.
Because I was understanding myself.
Sorry. Very sorry.
What is the order?
Sorry.
What is the order? Whether any counter affidavit was filed in that case?
No, my lord.
Then what is the order? What is the effect of the order? Consideration.
Lord.
And whether you are entitled to or not will be decided in contempt jurisdiction.
But what?
You can file a writ petition. The petitioner has filed the present contempt application alleging disobedience of an order of this court dated 9/10/2020, passed in WPC number. The petitioner had approached this court with a grievance that he was not being given benefit of appointment on compassionate ground under a rehabilitation assistance scheme. So stop. Next. This court disposed of the writ petition with a direction to finalize the issue of providing appointment to the petitioner under a rehabilitation assistance scheme, keeping in view certain developments. So stop. An affidavit has been filed on the so-called affidavit has been filed on behalf of opposite party number 2, wherein it has been stated, inter alia, that the petitioner's case for consideration of appointment under RA scheme falls under new scheme.
What we have said is that because the new rules have come into the picture, and as per rule 6(9) of the regulation, all the pending matters will be dealt under the new rules.
But that has been struck down by
all the pending matters for grant of appointment on compassionate ground are to be considered in accordance with 2020
rules.
What is the name of that rule?
The rules are Odisha Civil Services Rehabilitation Assistance Rules 2020.
First off, the petitioner was asked to make an application. Make a fresh application for consideration of his appointment under the said regulation or rule. What is that? Said rules. Petitioner has not made any application. First off, next, learned counsel appearing on behalf of the petitioner has submitted that the said rule has been struck down.
It is against the order of the Honorable Apex Court. This
counsel appearing on behalf of the petitioner has submitted that the stand which the opposite parties are taking is contrary to law laid down by the Supreme Court.
In the case of Malayalam city?
In case of Malayalam city.
What's the state of Orissa?
So the said aspect cannot be gone into in a contempt jurisdiction. Also, stop. The petitioner shall have contempt jurisdiction. Stop. No case of intentional disobedience of this court's order requiring this court to proceed under the Contempt of Courts Act is made out. Stop. The contempt proceeding is dropped. The petitioner shall have liberty to question the decision of the opposite parties in appropriate forum in accordance with law.
The decision was never supplied. It was only filed before your lordship in the second. No decision. How can I impugn it? You let them supply a decision which I can challenge before your lordship in the writ petition. Now the affidavit, first time it has come in the affidavit, madam.
The
Notice.
letter has been issued to the petitioner on 6/10/2020.
That is prior to filing of this writ application. What they say is prior to filing of this writ application. 6/10/2020 is prior to filing of this writ application, which your lordship disposed of on 9/10/2020, madam.
And
So
was
let
that-
them at least issue which I can challenge before your lordship with the liberty. Because
What is the What is the date of communication of that letter?
after filing of the writ application, my lord, the writ application was filed in the midst of COVID, my lord. Lordship, situation, this was
What is the date of that letter?
6/10/2020.
And when was the order passed?
9/10/2000, 3 days after, and it did not receive. I did not receive it after only filing of the writ application.
So therefore, had they been given an opportunity to reply to the counter affidavit,
Because during COVID
they
times,
might have brought on record this communication,
no, the-
and thereafter an appropriate order could have been passed. Yes.
Item 41.
My lords, item 41 SL 4658/2024 is.
Last occasion, my lord, I directed them to serve a copy, but they are not supplied.
Serve a copy of what?
That they have filed an additional affidavit. In spite of twice dismissal of SLP, it was again restored. They have taken that.
It has been restored.
It's my lords,
They have
by
taken-
order dated 14/11/2024.
Once it was due to non-filing of requisite, it was dismissed. Restoration petition was filed. Again, it was withdrawn. Thereafter, they have taken the plea that on 14/11, it has been again restored.
It has been restored. What can we do?
Matter, I have no doubts. For that reason, my lord, I directed them to serve a copy.
A copy of what? Order.
That affidavit. Which they have taken.
Serve a copy. Have you served?
I will come next week.
Next week.
Item 42.
My lords. The order dated 26/2021 has not been complied. Only the affidavit file that executable is pending. Only affidavit that file executable is pending. But the executable that defect not removed for which my lord client directed, then it what happened to the defect. In the executable, no children defect not removed. That was passed by my lord on 20/24/2023. My director to remove the defect. Till that neither defect nor listed. And on the only affidavit that is pending. Executable of the year 2021. Till that defect not removed. Then my director last of the job on 8/11 to
It is
tell what happened to it. Whether it's removed or not.
the petitioner's case
They have not
that
had any approval thereafter. Last of the job, twice my director. So then on 18 to tell what happened to it.
yes, why are you not removing the defects?
Check my lords. Check the case status still showing pending.
But he is saying that it is
21, even 21. Not taking any step for removal for disturbance. I could have filed memo for listing, but not.
a so-called reply has been filed in behalf of the opposite parties, stating therein that a writ appeal has been filed against this court's order dated 16/3/2021, violation of which has been alleged in the present contempt application. The top learned counsel appearing on behalf of the Petitioner has, however, submitted that no writ appeal in the eye of law is pending, in as much as writ appeal said to have been filed on behalf of the opposite parties is still lying defective. So stop. List this matter on next Friday. So stop on the next Friday. If the order of this court dated 16/3/2021 is not complied with, the court shall consider initiation of contempt proceeding. Yes.
Item 43.
Order is complied with, my lord.
44. 45.
Honor debtors 80 level.
40, no? 45, what happened?
Order dated last order. Order
Yes.
dated 8/11/2024.
Hit 11. Yes. Where is the order?
Already similar matter SLP dismissed.
Yes.
2 weeks time will be granted in this.
2 weeks further is 2 weeks further time is allowed for the contemptors to ensure compliance of this court's order.
46.
Yes.
The judgment order 36/22 has not been complied despite dismissal SLP. SLP was dismissed and in additional affidavit. 20 September 24, SLP has been dismissed.
Where is the order?
Order by Annexure 1, page 12, the judgment matter. And the operating long judgment matter. Operating parties at page 28. Paragraph 3 and paragraph 13 and 14.
Page 28.
28, madam. Long judgment matter. The director to take over to secondary cadre and give the benefits. Because we are the put under the shared cadre or portfolio ME school, which is elementary cadre. For that reason, my director to them to their own cadre and give the consequential benefits. The long judgment and after hearing all the parties. And they have my not dismissed. Again, SLP dismissed on limitation on that matter of 2022 and
The learned counsel appearing on behalf of the petitioner has submitted that this court's order dated 36/2022 passed in WPC bracketed OAC number 3476 of 2016 has still not been complied with, despite the fact that an SLP preferred before the Supreme Court arising out of the said order has also been discussed. Stop. This matter on 4 weeks. Stop. In the meanwhile,
I thought 2 weeks.
4 weeks for the reason. When was the order passed?
20 September 2024.
20 September 2024. So they had a valid reason.
Approaching the vacation.
4 weeks. 4 weeks. 4 weeks. In the meanwhile, they will comply with. Otherwise, again, they will come and seek time.
They have to comply with it.
Yes. 4 weeks. In the meanwhile, the opposite parties shall be at liberty to comply with the court's order. telling which court shall consider initiation of contempt proceeding. Occupy my chair, Mr. Yes.
Supplemental item 3, your lordship, as per the warrant, that has been already complied and money has been paid. I have passed on the letter, my lord.
Who is for the other side? Inform him.
I am calling him.
Item number 47.
In the last order, you are directed to comply the order within a period of 2 weeks. And in the meanwhile, 2 months have already gone. Till today, they have not given the PTN's report. It is a matter of 99, 75 years old.
Let me see the order.
Yes, order I have quoted in page number 4. Page number 4, para 12. Operating portion. Therefore, this court, while interfering with the said order, is inclined to quash the orders of Annexes 6A and B to the writ petition. While quashing the same, this court directs the opposite party to extend the financial benefits as due and admissible in favor of the petitioner for the period from 25/4/1995 to 30/9/2013, and with a further direction to the opposite parties to sanction and disburse the said financial benefit within a period of 3 months from the date of the order of the receipt of this order. The petitioner is directed to provide a copy of this order before the presence. A direction was the order was passed on 20th/10/2022. In the meanwhile, 2 years have already passed. But till today, they are not taking any action, and they have taken 3 to 4 times.
So who has not complied with?
Opposite party number 1, that is opposite 1 and 2. Secretary,
direction is to
and the
whom?
director. They are responsible.
Who was required to?
Director is responsible. That is opposite party number 2.
When counsel appearing on behalf of the petitioner is correct in his submission that this court's order passed on
2010/2022.
2010-2022 in WPC number so and so has still not been complied with, and therefore case of gross disobedience of this court's order is made out. So place this matter on next Friday, when we ask him to be present, when the director, when the director, so what is it, please, director what?
Director of secondary education. Director of secondary.
1 week time may be granted to change instructions.
Director of secondary education also.
When the director so and so shall be required to join the proceeding online for this court to consider initiation of contempt proceeding against him.
48.
But why has this happened, madam? The order was passed in 2022 and we are in 2024 for 2 years.
Actually, in the order, the petitioner have been granted in par with one other petitioner in question. Some instructions are there in the file how they are different, but most focus have.
No, but still there is a direction, specific direction.
That are decided.
So just a minute, sir. So there is specific direction. So finally, if on next Friday, if I am satisfied, even if you comply with the order, I may initiate contempt proceeding. It's a gross thing that someone has to wait 2 years for implementation of an order after adjudication. So you can warn him, caution him that even if it has not been complied with, then it's a very serious matter. If it is not complied with, even on next Friday, more serious. And the court will consider, even if it is complied with, whether this amounts to contempt of court or not. Person cannot be let off like that. If your intention is clear, then our decision should also be equally clear. Yes.
Item number 48.
In that regard, judgment detailed 24/22 has not been complied. Despite dismissal of SLP.
Just a minute.
There's one SLP which is pending in the similar batch. SLP diary number 28667 of 2024 is pending. One batch SLP 2066624 has been disposed of. One SLP is pending in this batch.
So, but batch means what?
Similar.
Four cases or tag together. Four cases tag together. One common judgment is a passed. Three is the four readable file. After long lapse of 588 days. After long lapse of 588 days. Both the three readable dismissed on limitation. Supreme Court, Appeals Court. Appeals Court dismissed one SLP on threshold, not limitation, on limitation. Second case, my lord. Second case, the connected case, they have only issued notice on the question limitation. No stay nothing. On limitation because of 588 days for constituency. In one case, they have dismissed the SLP on the threshold. That is on detailed. 3 now September 20. That is Lakshmindra Baraki, past SU display.
So whether SLP has been preferred against this order?
Yes.
Yes, my lord. On 9/8/2024, notice has been issued in Vijay Kumar Naik was matter, my lord. State of Orissa versus Vijay.
And what about this Lakshmidhar Behra?
That is disposed.
Dismissed.
Then you will have to implement.
But my lord, the similar issues are pending.
Maybe. But this is inter party.
2 weeks may be granted.
2 weeks time is allowed for the estate to seek instructions for the opposite parties. 2 weeks time is allowed to learn ASC to seek instructions and file so-called reply. Does this case 2 weeks? Yes.
And the connected case, my lord. The second case, the man expired in the meantime. I have filed a petition for a substitution. That man expired. After retirement of teacher, he expired without pension. I filed petition substitution. That may allow. Second case. He expired in the meantime. I filed a petition for substitution.
Charan Jana.
Yes, ma'am. Yes.
IA number. So IA is not here. Let it come next year.
Item 49.
In and my lord, despite dismissal of petition by my lord on 6/4/2024, till date the order of decision court dated 20 September 22 annexed 1 and not in compliant. Directed to regularization service, regular service.
There was a direction from the School and Mass Department that these candidates should pass the Orissa Technical and Educational Training. The second petitioner, in the meantime, the pendency of the case has taken that training and she has been regularized. But this authorities have written to the government as to what steps should be taken because this person has not yet completed the training. But she has come with instructions to be.
My submission is
Otherwise, they'll comply with what that is what.
my submission, my lord. I have appealed for 8. So OTD is not applicable to my case. That I decided decision court. OTD is not applicable to my case because OTD came from 2012. I joined on the 8th, my lord. So that therefore, my lord, I decided it is not applicable to them. Those happened thereafter because OTD they shall be compared to.
That I will not go into such disputes.
Written to the.
And therefore, my director regular services. And they are not compliant till date. I will
So let them file affidavit.
Yeah.
Week's time is allowed for the opposite parties to file so-called.
And for that only file affidavit. I have file affidavit. I have referred matter to government and see the affidavit. File affidavit. Government is still opening to one sitting on the matter. Secretary of the department.
You have filed already?
Yes, it is file affidavit.
But this distinction is made and the collector has written to the government to seek clarification as to how to regularize him because of this impending.
My director, collector, for regularizing, they have instructed.
He has to get a note from the government.
To seek further instructions and file additional so-called reply.
I will return my March, my lord. Only 3 months left retirement.
2 weeks, your lordship.
Fix it there, my lord.
Make a mention of the next.
2 weeks, my lord.
Item 50.
50, your lordship, a revenue case has been initiated, your lordship, instituted also, and the petitioner is appearing there, and the next date has been posted to 12/12/24, your lordship.
Complied with?
Last week is the state took time to file the complaint. Instruction was very good. Posted to 12th of December, your lordship.
Which December?
Of 12th of December, your lordship, for the hearing, your lordship. The petitioner has also been noticed and is well aware of it, your lordship, and also has appeared on 22nd of November, your lordship. Before the authority, your lordship.
Where is the order? No, where is the order of this court? Which according to you has been violated.
The contempt application is the original rate application order has not been annexed by reproduction.
You have not annexed.
The second contempt application.
What was the order?
The petitioner filed the rate application when the mutation case has been disallowed. This honorable court, after hearing the counsel for the state, is directed and remitted back the matter with fresh adjudication of the mutation case. Despite the direction, when the mutation case has not been adjudicated, I filed the first contempt application.
No, what is the, so was there any direction to conclude the mutation case?
It's been remanded to fresh adjudication.
So now they are doing it. It is an admitted fact that pursuant to this court's order dated so and so.
5/1/2020.
5/1/2020. 21 passed in WPC number.
34352 of 2020.
The mutation case number. Mutation case number?
Mutation case number 10627 of 2019.
Is being reheard. Is being reheard. Is has been taken as risk by Tahsildar. By Tahsildar, which place? Tahsildar, which place?
That
Check me. Post op in such view of the matter. In the court's opinion, no case of intentional disobedience of this court's order is made out. Contempt proceeding is dropped. Yes.
Item 51.
The order dated 27/4/2023 for division number pension and pension benefits. The order dated 27/4/2023 annexed for page 12 annexed 1 answer 2 that not be complied for division number pension and eligible pension benefits. And my lord directed in second round second content word earlier directed I again filed first content that was disposed of on 5/9/2023 to comply the order.
Yes.
You did that not
2 weeks time.
Weeks time is allowed for.
in some case subsidiary would not occur last
The-
one more than one.
Yeah, as requested by learned AG, list this matter on 2 weeks so as to enable her to seek instructions, file so-called replies / compliance affidavit. Yes.
Item 52.
So order 3/5/21 have not complied. Last of the
Where is the order?
so page 11 or 6 and step 2. Now operating party after page 15.
What is the order?
Till disposal of the reproduction in the petitioner under annexure 7 as opposed to number 2, the status quo in respect of the land as described above shall be maintained, and this shall be completed within 4 weeks.
Yes.
Similar status for your lordship I think instructions, what we have here in the file is that the status quo has been implemented by the collector, your lordship. What has happened? Further, your lordship, I think instructions and file and reply, your lordship.
Same order.
Item 53.
Your Soko's affidavit is filed.
Yes.
Yes, already your file is complied with.
And it's Soko's affidavit that is maybe
Maybe
supplied.
another copy or.
I only request my lord for 1 week time.
No, no.
Through this.
Let me see the nature of the order and then
Yes, my lord. Yes, my lord.
nature of compliance, and then if required, I'll
Yes.
surely give you time.
My lord, the operative portion is at 18. It starts with, my lord, page 17. May I read now? After observing in the above matter, the Honorable Apex Court, considering that there is a long lapse of time in the meantime, but for the stigmatic order passed therein without entering into the detailed inquiry or giving opportunity, the Honorable Apex Court, while directing the petitioner therein to be reinstated in service and back wages, and also to allow continuity of service. Perusal of the informed order on consideration of the submissions of the respective parties involved herein. This court observes that there has been no following of principle of natural justice involving the case at hand for the.
So whether the decision, any decision has been taken.
Yes, my lord, it is only the payment of arrear, my lord. That is the word. Payment of arrear, if any, will be dependent on the ultimate outcome in the matter of continuance of the petitioner. My lord, in the instant case, the petitioner continued till he got superannuated, my lord. So my arrear salary is pending and they have only disbursed the salary on the heading of salary. That is with regard to payment of arrear salary.
Whether there was any action initiated against you.
No, my lord. No action. Till my superannuation, they did not, and I obtained a stay order before this honorable court. And I superannuated on.
Madam, there was any order passed against you. There was some order. Now please come to this court's order at page 17.
17. Yes, please.
Read after observing.
After observing in the above manner, the Honorable Apex Court, considering that there is long lapse of time in the meantime for the stigmatic order passed therein without entering into the detail.
So there was an entry, a stigmatic order passed against you.
My lord, no stigmatic order. They only after I got reinstated, they issued one so cause notice, my lord. And no inquiry, no further inquiry, nothing. And I got a stay order from this honorable court. And in the meantime, I got superannuated. Therefore, the order which passed by this honorable court has not complied with.
What was the order?
My lord.
What is the order passed by this?
In this another writ application.
No, in this case.
My
you are
lord, this
alleging.
case is the payment of arrear salary, if any. It is the outcome will be dependent on the outcome in the matter continuance of the petitioner. I continued till I got superannuated.
Outcome.
I got superannuated, my lord.
You'll have to read the entire paragraph.
Yes, my lord.
The court says that this court, while interfering with the impugned order,
yes, my lord.
There was an order impugned. What was that order impugned? You are saying there was no order impugned.
Order for dismissal. That has been.
This is what
Yes, my lord.
I'm saying from the very beginning.
Sorry,
That there
my
was an
lord.
order against you. You are saying there was no order against you. Then it says, it recites the same, but however, considering that Krishna has not worked out all through, this court, while directing for reinstatement of petitioner in post forfeit, observed that since a fresh look is required to be given on issue involving the petitioner, payment of arrear, if any, the fresh look is to be given, will be dependent on ultimate outcome in the matter of continuance of petitioner.
Yes, my lord.
So whether any fresh order decision has been taken on your dismissal, Department of Proceedings.
No, my lord. No fresh order has been issued, my lord.
Then they will consider.
Yes,
No
my
case of no contempt is made out. the petitioner has raised disobedience of this court's order dated 10/1/2018, passed in OJC number 15726 of 1998, operative portion of which reads thus: perusal se lekar stopped. So-called reply has been filed as on behalf of the opposite parties, from which it appears that this court's order has been complied with. Complied with in as much as the petitioner has been paid arrears of salary for the period 10/7/2018 to 28/11/2013 after deducting the income tax amount. Further, sum of ₹3,90,529 has been paid towards allowance for the said period. And counsel appearing on behalf of the petitioner has, however, submitted that he has not been paid. Which amount? Everything has been paid right from 18 to 23.
Arrears salary. The word is clear. The payment of arrear, my lord. My lord, I only liberty may be given.
So the contempt proceeding is accordingly dropped. Stop. If the petitioner has any grievance as regards computation of his entitlements, he shall be at liberty to approach appropriate authority by making a representation. Yes.
I could not find the hard copy.
It's there. Yes. Item 54.
Lordship, yes, I have contacted the CDMO Sambalpuri Lordship. She is in the country, your Lordship. She has requested 3 weeks time for.
No, but what was the order?
Petitioner was standing in a similar footing in the Rakesh borrowing case, and similar benefits to be extended towards the petitioner, your Lordship. This case has already been decided of the Supreme Court also, your Lordship. And it has been confirmed. It's out of the country, Lordship, so she.
Some CDMO must be here.
Lordship, but she was the one. I had spoken to her. She said that this was her last chance with 3 weeks time. I'll be back in.
As requested on behalf of the opposite parties by way of last indulgence, the matter is adjourned to 3 weeks. Stop. In the meanwhile, if the order of this court is not fully complied with, order of this court violation of which has been alleged in the present contents application is not fully complied with, the court shall consider initiation of contempt proceedings.
55.
Complied with your Lordship.
Give him compliance.
I'll serve it.
From 56.
Complied with your Lordship.
Complied with.
For the land in my favor, for the occupier on the construction made over that is not.
All it has been complied with, not complied with. Yes.
Item 57.
57, I'm appearing after receiving notice, I'm appearing today, I'm appearing today for the opposite party. So this appeal is now pending.
Writ appeal is pending.
Number
appeal.
Number
58.
Please, your lords. The order of this Honorable Court has not been complied with. It was
passed on 59/2023. Thereafter, first contempt was filed, and the petitioner is a teacher. And if at all in the event the order is complied with, it will lead to some financial implication. This must be. So, but no compliance has been made. First contempt also order was passed.
Where is the order? First order. Let me
Yes,
see.
first order is page 8, your lordship, I can see. Yes, so page 12, your lordship, I can see. Paragraph 6. May I place, madam? Having heard learned counsel for the parties and taking into account the submission made, this court is inclined to quash the order dated 18/5/2023. So available at annexure 4. While quashing the same, this court remits the matter to OP number 2 to take a fresh decision with regard to grants of pay protection in favor of the petitioner.
27/11/2024. The matters. In the said affidavit, we have stated that at para 7, then office order by dated 10/4/2024, the copy of the said order has been forwarded to the petition. Sorry, Milas. We have sent a letter to School and Mass Education Department to solicit necessary instructions in the matter on 9/2/2024. And thereafter, a letter has been received from School and Mass Education by stating that taking appropriate action regarding release of arrears salary of ex-servicemen teachers and attendants previously working in school. So in this matter, some time may be granted and it will be completed.
I want also copy.
But on the other hand, the other matter, contempt petition number 4137 of 2024, the petitioner is not similarly placed. His name does not reflect in the order at page number.
How many contempt? Two matters are there.
Yes, my lord, 2 matters are there.
What about second, according to you, in the second contempt, second matter, you have complied with?
No, my lord, in the second matter, my lord, the affidavit and proposed affidavit dated 27/11/2024, wherein we have reproduced order dated 2011 of the Director Elementary Education, saying that Karunakar Rao regarding the release of arrear of ex-service workmen so-and-so, the report of the so-and-so has already been moved to the mass education in order to solicit necessary instructions. And since the above amounts so-and-so, the name of Karunakar was not proposed due to non-receipt of claim of Raut for arrear salary during under IEPC scheme from October 1993 to November 1995. That has been mentioned in the proposed affidavit.
We'll see both the cases.
The total claim is 50,000, 4 times of litigation. 50,000 is total claim. The arrear salary, I have worked, period is specified, identical teachers have got, but 4th journey, this is the 4th journey, 4th teacher. Anyway,
this should be the last journey. You are taking so many journeys. File petition, then contempt, then contempt. Let it be
under the
concluded here.
circumstances, I am supposed to file. Second contempt is not necessary, but
yes, yes.
So, my lord, both the matters to accept.
My lord, supplementary item 3 I mentioned, we have complied. Your lordship asked for warrant over. We have already complied and amount has been credited with us.
I would show you, not credited.
Just
just upon the about the aging jaito, there are
Today morning, I also talked to my client.
Yes.
There's nothing.
Sir.
My lord. My lord.
Let me see, where is the order?
Page 22, content. May I read this?
Just a minute. Page 22. Paragraph 8.
Yes, sir.
Yes.
In this process, while observing the impugned order annexation 9 is bad, this court, while setting aside the impugned order at annexation 9, direct the petitioner be entitled to scale of 900 such and such with effect from 17/12/2005. That is the date on which he was posted as principal. Since almost 15 years time has already been passed in the meantime, this court also observes in the event there is any further revision of meantime, petitioner will also be entitled further revision in scale of pay, such and such. So long as the petitioner held the post of principal along with revision in the scale, in the meantime, since the petitioner is superannuated during pendency of the OA, his pension is also be accordingly fixed. While treating the petitioner as above, the entire calculation of differential area
has been done.
That area pension regarding revised area pension and the pension have not yet been revised, Miller. Today morning.
No, this is the instruction which he has received.
Your Lordship, they have yesterday filed a so-called, served a so-called, this is the letter dated written to the principal AG that you come with this, Miller. There is no compliance, revision, area revision, pension has not been paid.
All right. So item number 3 में करना. And GA appearing on behalf of the state. But why is he not present?
Hello?
Why was he not present?
That is credited to the account, that is, the letter says, later by handed to your lordship, it says that with 5% interest.
When was that communication made to the AG?
Yes, sir.
What is the date? Why are you showing that?
Yes, sir. 21/11/2024.
Item number 3 का पूरा order card है. GA appearing on behalf of the contender states that the court's order violation of which has been alleged in the present contempt application has been fully complied with, as per the instruction which he has received from opposite party number 2.
2 months.
So stop. What is this case on? Next week.
Let that copy be.
I will hand over copy.
Weekly list. Weekly list.
Weekly list item number 1, COLTC 644 of 2019.
My lord, in this case, this is related to regulation 2 of 56 on private lands on construction is going on. Honorable High Court directed to maintain status, sub-collector to maintain status quo in the order and communicated the order. And also communicated order to IH Udit Nagar to take steps against long back. So that way we have complied the order and status quo order has been maintained in 13/12/2019.
Petition on behalf of the petitioner to press the present contempt application. So from GA appearing on behalf of the contemners has stated that the opposite parties have complied with the order of status quo. So stop. The application, the contempt proceeding. This application is accordingly dismissed. Yes.
Item number 2.
And already complied.
Compliance.
Compliance have it tried. Compliance you not issued.
Notice.
I will give you the compliance.
Yes.
Item number 3.
If he will also. Indian Council, Mr. Gantry, about this leaving this matter, there is some medical discrepancy, and spring of which I pray for 1 week of time.
What is the
Well, writ application was
not given to us.
writ petition is pending?
Indeed, my lords, writ application is pending and interlocutory order was passed to not to take any coercive action against the petitioner. But subsequently, by the Office Order 86 of 2019,
Just a minute. Let
copies of
let CONTC 653 of 2019 be placed before appropriate bench along with WPC 2613 of 2019 as per roster. Yes.
Item number 4.
No, man, copy we have not received.
4. Yes, someone is there. There is no representation on behalf of the petitioner to press this contempt application. Contempt proceedings stand stop accordingly. Yes.
Item number 5.
And order already complied, man.
Complied.
Item number 6.
6 copy.
Complied.
Complied. 6 I have not received copy.
So cause it has been filed. Yes. Example. Here for whom? Only contempt. There is no representation on behalf of the petitioner and counsel for the contender are present. What is the so-called? I think I can comply with it. It is the stand of the opposite parties that the court order has this court order violation of which has been alleged and complied with it. Contempt proceeding is dropped accordingly. Yes.
Item 7.
7 may appeal. I am petitioner and the order dated 10/4 of 2019 has been violated by the opposite party ownership and it is directed for maintenance status over this property ownership.
CMP is pending.
Yes, ma'am.
Both cases will be heard together.
Yes, ma'am.
Even copy have not received.
That is state. Over to private.
No.
Public.
List CONTC number so and so along with CMP and so and so as per the. Yes.
Item number 8.
8 will have complied. Evicted from the government land.
Yes.
Item 9.
9 copy do be.
Item 9 and 1. Already completed.
Complied. Yes.
Item number 10.
Not complied.
Disposal, my mutation that and disposal, my lord.
Complied with.
Complied.
Item 11.
Copy not short, my lord.
Sorry.
Complied with.
Not compliant.
What is the order?
I have not received the copy.
Just a minute.
There's 8 million. I still 1 million.
This is item number 11. 11. 11.
My lord. My lord, in defension is rejected on 27/11/24 month.
Yes, it has been complied with. Complied with.
Item number 12.
Item 12, my lord, I will press the application as it is become interruptus, my lord.
Item 13.
The order was passed on merit since 2018 minutes. Since 2018 it has not been complied with, even though there is a order from this honorable court earlier in the contempt application. But people also will kindly gone to page number 16, running page 16. This is the operative part of the order. It's a directed inter-exchange shall be completed within a period of 3 months from the date of communication of this judgment. Let's against that, they preferred a writ appeal, and that writ appeal has been dismissed. It has reached the final date, but till date 6 months, 6 years has passed by in the meantime. Contest this order was passed. Operative part is paragraph number 9. Starts from page 15, it ends with page 16.
What is the direction?
Direction, if you also will see, it is a promotional post. They wait for a regular recruitment. So that was challenge that was quashed, and it will also will come to paragraph number 9.
What is their stand in the so-called reply?
So-called their file, it was here. We will also will come to paragraph number 9, page 15. It is there. For the observations made herein above and for the bringing the recruitment rules by Annexure A clearly establishing the mode of selection for the post of assistant professor, prosthetics operating in the year 1990 and by a promotion, building with direct recruitment, this court finds mode of selection involving the advertisement.
Yes, sir. So after dismissal of the writ appeal, you should have proceeded further.
Union of India. Union of India.
Who is appearing?
My lord, I am appearing. My lord, I will take instructions also filed in, my lord, affidavit, my lord.
Learned counsel for the petitioner has submitted that despite dismissal of the Lieutenant Court appeal preferred against this court's order, violation of which has been alleged in the present contempt application, the said order has not been complied with. Stop. In the present case, a preliminary so-called reply was filed on behalf of the contender, taking plea of pendency of a writ appeal for non-compliance of this court's order. So now, since the writ appeal has been dismissed, I do not find any reason why the said order of this court should not have been implemented. Stop. Unless this case 2 weeks, stop. If in the meanwhile no steps are taken to implement the court's order, the court shall consider initiation of contempt proceeding because it cannot be complied with within 2 weeks.
My lord, one copy to serve, my lord, Union of India. I have no copy, my lord.
Is he your friend? Whether the counsel for the petitioner is your friend? Is your friend or not? Or his enemy?
My senior.
He is your friend. He'll give you. Why do you require any judicial order?
My lord.
Item number 14.
14 order declared 23
The remand revision was sent to the sub-collector disposal. What has happened, it depends on disposal of OLR case for which we have called for the record from Pujam Tahsil. But Tahsil has read readily that OLR can record, not record. So 2 weeks may be given so that we'll take steps of retracing of the record.
Where is the order?
That order I have put at a page 2 on my contempt petition. Order dated 23/8/2016. Considering limited request involved in the writ petition, this matter stands disposed of. Directly OP number 2 dispose of a remand revision number such.
No contempt. No contempt is
providing opportunity. And thereafter also another order was passed.
No, that I'm not satisfied. No contempt. The petitioner has
pending since law. Is a consultation proceeding after remand of the case from the commissioner consultation to the CO Kujang, the matter is pending there. And that way I have been pending. The land which I have owned would not be recorded in my name. Man, don't ask him for time, some time and time.
Time he is taking some stand. And that stand could have been taken when the writ petition was disposed of.
That was not knowledge.
That was not within the knowledge.
Because
And therefore the order.
because the non-cooperation of the Tahsil, that time government office.
He bases his claim on basis of the order in the OLR case. So we are asked for the OLR case. That is not traceable. Tahsil takes some time to it. To record.
As requested by learned GA, this matter on 2 weeks.
Item number 15.
Allowed, mind the 10 gadgets के लिए allowed order complied.
Compliant.
Item 16.
16 means this land cannot be settled. It is the government land and this is only using as a passage. We said we can use it as a passage, but you cannot put construction over their land. So in case for lease out of land has been rejected.
Also, we are not approximate.
No, that has been rejected. Your claim has been rejected. Compliant with liberty. Yes.
Item 17.
On appears.
It is been complied, my lord.
Application. It is stated by learned GA that court's order violation of which has been erased, it has been complied with.
17.
Yes.
Item 18.
Yes. There is no representation. In behalf of the petitioner.
Complied, my lord.
Application.
By order dated 22/12/23.
Reply has been filed. So in compliance of this court's order, violation of which has been erased, consent proceeding is dropped. Yes.
Item number 19.
And already complied.
Complied with.
Item number 20.
Compliance affidavit. One appears, compliance affidavit filed. Yes.
Compliance affidavit I have filed, my lord, already.
Yes.
14/8/19.
All right.
Item 21.
21 complied with.
22.
Complied with.
Item 23.
23 also complied.
Complied with.
24.
24 already
Complied with.
Item number 25.
Like it is not complied.
Complied.
Not complied by. Lost directed to dispose of the mutation proceeding with the stipulated period. It was not disposed of within that period. I filed a contempt petition. This court directed, extended the time period for compliance. It has not been complied.
Yes.
In this case,
in
this case, also for instruction that we already been complied. Not that.
No, but in this case, suppose reply has been filed.
So much has been filed. Our stand is appeal has been prepared. Para 5 everything.
So called. Copy may be provided to me.
No, there is.
Copy.
See, there is a civil suit mutation.
On the civil decree, on the basis of the decree, my lord, I filed the mutation case, my lord.
There is an appeal pending.
Yes.
Appeal pending, my lord.
So you did not disclose that.
No, appeal was, I had, at that time, I had not received notice. I have not taken instruction from.
All right. No, in this case, in this supposed reply, it has been stated. See, mutation case has not been disposed of because of pendency of appeal against decree passed by, which is subject matter of the petition.
Actually,
the supposed reply has been filed on behalf of the opposite parties, wherein it has been stated that this court's order dated 26 to 2016 in WPC number 3046 of 2016 and 3047 of 2016 to dispose of the mutation case has not been complied with because of pendency of appeals against the decree passed by the Civil Code bracketed Senior Division Bali Guda, which was the basis for the petitioner's case in the mutation proceedings. So contempt proceeding is accordingly dropped, as I do not find that any case of deliberate disobedience of this court's order is been out. Yes.
Item 26.
Same.
27. 28.
8 and for the opposite party already complied with.
From 29.
29, my lord, the direction was, if application is submitted by the petitioner, then they will be considered. Till that, no application has been received.
There is no. This is 29.
Yes, sir.
This is 950, 29.
Drop.
Item 30.
Copy has not been served.
29.
30 called. 30, item 30.
No, there's no representation to on behalf of the petitioner to press this application. Contempt proceeding is on. Yes.
31.
Model.
32.
Complied, my lord.
Complied with.
Item number 33.
33 also compliance.
Complied with.
34.
No one appeal. Yeah.
35.
Same as 34. Same as 34. The earlier.
Yes.
36.
36. We have not been able to find it.
Directed for consider the representation and dispose of the witness stipulated as it is a covered matter of the case.
Order passed. It is complied with. Complied. Yes. I'll give a copy.
Yes.
37.
57, your lordship, on
37 is
copy of this 2020 for an additional affidavit was filed. Lordship may see that additional flag C, your lordship, where I've explained that what are the benefits that are to be given to me. And to that effect, they have also filed a show cause affidavit, which is at flag B on 4th October 2022. And at para 6 of that show cause affidavit, they specifically admitted that thereafter necessary steps are being taken sincerely for sanction on the serious benefit in favor of the petitioner. As of now, whatever I have the instruction that no benefits has been given to the petitioner.
Read appeal has been preferred. That is WA number 384 up to 2016. That is pending.
Yes. Read appeal has been dismissed. SLP has been dismissed. In para 3 of the so called, I've explained that already benefit has been given. Only the CAS, Career Advancement Scheme, he has to file some documents. And some documents are missing in the office, so it takes some time to comply. That is what has been delayed.
Yes.
Already have complied.
Lordship may see para 5, your lordship. Para 5 of the show cause document. Show cause document filed by the para 5 of the page 4. Page 4, your lordship. Sixth from the para 5, sixth from the bottom. At page 4. May I read it?
Page 4.
Page 4. And para 5,
page 4 of the so called reply.
Yeah, look. On the 4th day to the which is at flag B.
Additional, no, so called.
Show cause.
Page 4, yes.
Lordship, in the 6th line from the bottom, they are specifically mentioned that so the performance reports are of the petitioner was collected from the CCI cell of the university, who submitted the said report on 28th August 2024. And the following para, they are also saying that they are taking steps, yet they are yet to comply. And the amount which I have claimed, your lordship, which I am yet to receive, which is at the additional affidavit at flag C, your lordship would see. Flag C of the flag C at page 6, your lordship. There's a table. Revision.
6
The table at page 6, where I have claimed that on amount of rupees 1,10,83,182 rupees, which is estimated, and I'll be getting. The year to comply with this. But I may request your lordship, let they get back with the compliance affidavit in the next period.
You'll have to comply with it.
There was no determination regarding amount.
No, not against your amount. See, you are admitting that you are taking steps.
Yes,
to
yes.
conclude this.
You also will kindly come to para 3, page.
Para 3.
Para 3.
Yes.
That is humbly submitted in pursuance of Warrant dated 29/3/2016 passed by this Honorable Court in OJC number 9754 of 98 by the petitioner Dr. Mahar Naik and culminating with dismissal order dated 14/2/23 of the Honorable Supreme Court. The opposite party has allowed the petitioner the post of assistant professor equivalent to reading experience. Reads and declares the SMS practice. It was equivalent to the assistant professor with effect from 25/7/2007. Wrong this is 1. By office order to such and such. Accordingly, his pay was fixed at 8,000 scale of such and such. And that's
See, Mr. You asked him to submit some document.
So far the CAS.
CS. So CS.
That has not been done. Let me get back within 4 weeks so that
No, 4 weeks. 1 week. Let them do it.
Your lordship, if your lordship will see the order annexure 1 of the contempt petition, what the court has exactly directed at page 26 of the contempt petition.
What is that?
It was a para 21. This honorable court had directed that the considering from all angles, as mentioned above, this court directs that the petitioner's case be considered as part which is counterparts, that is opposite party number 3 to 7, with regard to the regular absorption from the date of issuance of annexure 3. And since in the meantime the petitioner has already been regularly absorbed, the same should be related back to the date where similar benefits have been extended to opposite party number 3 to 7, and he be granted all consequential benefits as due and admissible to him in accordance with the law.
first part I have complied. Second part is only pending.
Comply with.
Will be 10 days time.
2 weeks.
All right.
It is an admitted position that substantial part of this court's order dated, it is an admitted position that this court's order dated 29/3/2016, passed in OJC number 9754 of 1998, has been substantially complied with. Stop. There has been delay in compliance of the order of this court for the apparent reason that writ appeal was preferred and thereafter an SLP was preferred before the Supreme Court. Writ appeal was preferred before the High Court and thereafter an SLP was preferred before the Supreme Court. The writ appeal and SLP both have been dismissed. Stop. In the SOCO's affidavit, in the additional, this is SOCO's affidavit filed on behalf of opposite parties number.
Opposite party number.
It's registered OU
1.
One, it has been stated that it has been explained, and so it has been the circumstance in which the petitioner's case for grant of CAS could not be considered has been explained. Stop. It has also been stated that necessary steps are being taken for sanction of CAS benefits in favor of the petitioner. Stop. List this case on 2 weeks. Stop. In the meanwhile, the opposite parties shall ensure that a decision is taken on sanction of CAS benefit. Stop. if the court will consider initiation of contempt proceeding if by the said date no decision is found to have been taken on the point of sanction of CA benefits. The top-learned counsel for the petitioner does not dispute that sanction of CA's benefit is the only component which has remained pending. Yes.
Lordship, will take instruction on that. What other benefits has there?
Yes, you have not filed anything.
38. Complied, my lord.
My lord, not complied. They have given annexure 3, my lord, to their compliance affidavit.
Yes.
Last
Where is
paragraph.
your annexure 1 to the contempt application?
My lord. That is the, so far as order of this allowance court is concerned,
Yes.
I placed, my lord, as a
What is the order?
Order your lordship will find.
Just a minute. Sub-registrar shall take a decision following provision of so and so.
My lord.
My lord.
So have you, whether any decision has been taken?
That is an excel.
My lord, can you give me glance to order sheet, that is annexure 3A of page 3 of their compliance affidavit,
Yes.
last paragraph. The sub-registrar received the letter from Tosdar, a report, inquiry report, on dated 19/6/2017. Although there was a direction to take decision within 1 month, they have taken decision on dated 27/8/2019. That is there. Then, my lord, kindly give a glance to the last paragraph.
Yes.
That is a proposal. Not they have taken the decision
All
whether
right,
the prosecution
that
has
is all.
initiated or not.
All right.
My lord.
The
They have to give the case number or whatever step has been taken by them.
petitioner has alleged in the present contempt application disobedience of an order of this court dated 21/3/2017, passed in WPC number 153 of 2017, whereby the writ petition was disposed of with a direction to the sub-registrar to take a decision based on report of Tahsildar.
Report of
Tahsildar. Post of compliance affidavit has been filed, stating therein that the order has been complied with. And counsel appearing on behalf of the petitioner has submitted that there has been nearly 2 years delay in compliance of the order of this court, and therefore a case is made out for initiation of contempt proceeding. To stop. Next, however, considering the subsequent conduct of the petitioner and the nature of order, violation of which has been alleged in the present contempt application, I am not inclined to proceed with the present matter. The contempt application is dropped accordingly. The contempt proceeding is dropped. Yes.
Item 39.
39 also complied with.
Complied.
40.
Complied.
The so-called reply has been filed by the director, whereas the direction was to the government. And the director says that para 4, what he has done after the communication of the order of this week.
Let me see the order first.
Yes, at page 7. Annexure 1, page 5, operative portion at page 7.
Yes.
Last paragraph. Upon hearing the learned counsel for the parties and going through the submissions as well as the pleading made in the writ petition and considering the fact that the matter regarding claim of the petitioner for UGC scale of pay which is pending before the Director of Higher Education, as such it would be appropriate to direct the opposite part number 1 Secretary Higher Education Department to look into the matter and take a decision.
Decision has already been taken. That's what I am submitting from the beginning.
Decision has been taken.
Commission will come secretary.
From private.
Your Lordship may grant me liberty to assess.
Liberty.
41.
41 may I plead. In CMP status quo was
CMP is pending.
and that was CMP pending.
All right, pending the
Obliged.
this contempt application along with CMP 181 of 2019 before appropriate bench according to the roster. Yes.
42.
Applied one.
Private.
43.
Compliant. Yes.
Already corrected award issue.
Item 44.
My lord, item 44, my lord. My lord, 44.1, 0.2, 0.3, and 0.4. All are the same cases, my lord, same, my lord. Kindly have a glance to the order sheet, my lord.
My lord, for the first time it is coming, my lord, 2 weeks time may be granted to either file correct.
My lord, kindly, it's a particular order, my lord. And next year one, page 11.
I will obtain instruction, my lord.
Read appeal has also been displayed. And next year one, page 11.
Notice has not yet been issued.
Let them, can I punish them today?
No. My lord, just for the, my lord's appreciation, I am saying. Annexure 1, page 11, operative portion is 13. Page 13, paragraph 7.
Let them file so-called reply.
In this case, read appeal has also been dismissed, my lord.
This matter on, as requested by the AGA, the matter is adjourned to 3 weeks. Let in the meanwhile, so-called reply is refiled on behalf of the opposite parties.
Not 44, 45,
Item 45.
and 47, 48, all are fresh matters, sir. All are fresh matters. For the first time.
My lord, item 45.
45.
Well, here if the petition is in the fag end of his life on 77 years ago, just for a correction of ROR, the petitioner fighting in 1970s.
Maybe you filed this contempt application very recently. When did you file? When did you file?
Well, it's 6 months ago.
6 months ago. And when did you make a mention?
Well,
Your matter is listed.
well,
Let them have 40, 45. Yes.
And for 46, the service benefits of the petition, promotional benefits.
Let them file affidavit. File affidavit. In 4 weeks.
47.
Is non-compliance of the orders dated 5/5/2022. And
Fresh matter.
File your
is the first content, this is the second content.
no contempt, one contempt. A second. Yes.
48.
Okay.
on behalf of Mr. Demarcation, not complied.
4 weeks.
Not complied.
49.
49 complied.
49 is complied.
Give him copy.
Because if I may humbly subject, with my lordship's leave, my lordship's order has not been complied in spirit. It has only been complied in letter, in as much as my lordship kindly sees the operative portion of the judgment dated 30/10/2023. At para 3, at page 10, if my lordship sees, para 3, my prayer has been paraphrased, and thereafter the operative portion of the judgment is from page para 6, my lordship.
Necessary order.
My lordship, pursuant to this order, I appeared before the contempt along with the judgments governing the field passed by the Honorable Supreme Court and our Honorable High Court.
That order may be illegal, Mr. Counsel.
My lordship,
challenge that.
My lordship, it is the contempt is my lordship's prerogative. I therefore bow down. My only submission is that no final call, as per the instructions received by me, my representation has not been disposed of. Finally, it is still pending. The learned contender has passed on the buck to his subordinate.
Therefore, I humbly submit that in spirit, my lordship's order has not been
Opposite part, no, opposite, who was opposite party number 2?
He is the contemner before the.
What is his name? What was the post?
Collector is the contemner before my lordship.
Collector was required, had the jurisdiction to pass the order.
Yes, ma'am.
All right, yes.
It is relating to rehabilitation assistance scheme. The collector has passed a rigid order on 4/10/2024. And I'm submitting the copy.
You can challenge that if you are not satisfied.
My lordship kindly peruses this order. Copy is
just think of a situation. You filed a writ petition. The writ petition was disposed of without hearing them, with a direction to pass an order. The order has been passed. Now you are saying that the order is illegal, and you want me to interfere with the order in the present contempt proceeding. How can that be done?
My lordship, I bow down. But my lordship only sees my predicament if my lordship.
Predicament, you just see the predicament, my predicament, that I have limited jurisdiction.
Because my lordship,
all right.
very liberty.
All right.
Lordship, in that case, liberty.
Surely, liberty, I will give. Liberty. Trusted by the counter on 51. Complied with liberty.
Item number 52.
52 complied.
Item 53.
Complied.
Item 54.
54, let's take up this matter next week. After having perused the court order dated 4/1/2024, passed NCR LMP 1164 of 2023, the court's opinion, no case of contempt of this court is met out. This application is conceived and is accordingly dismissed.
Item 55.
In this case, since the representation, through representation, it has dealt with by the opposite party, only my sole prayer that let the petitioners who are getting EPF pension only 2,000 to 3,000 only, let them file the application in proper forum before at office located at Bhubaneswar Court.
See, this is association has filed.
Association has filed since they are unable to file personally in different part of different districts. So let them prepare the application in the head of, since the head office is located at Bhubaneswar, through association, let them prepare the application.
No case of intentional disobedience of the court's order is without. The contempt proceeding is done. So, however, the members of the petitioner association shall be at liberty to file their applications appropriate performer before which authority?
Controlling authority under PGR Act at Bhubaneswar.
The appropriate authority. Application stands disposed of accordingly. Yes.
Item number 56.
Yes.
Matter relating to demarcation, Willard. The petitioner actually filed an application for demarcation. It was not conducted, for which he operated direction from this honorable court mirror. Now I have got the instruction, though the demarcation case is registered, so the instruction is they have put the wrong plot number and wrong khata number, for which demarcation could not be conducted.
No,
They may be
your
formally right.
this application is accordingly discussed.
57,
That's already complied with.
Compared with,
58,
Complied with.
compared with.
Compliance affidavit may be solved. Liberty may be given.
Liberty.
59,
59, complied with.
Compared with.
item number 60,
Complied with.
Rule compliant with the file.
Order.
Liberty will be given.
Liberty.
item 61,
The ones, 2 weeks may be granted in.
Give him a copy. You should take copy from him.
Liberty will be.
61.
61,
2 weeks time may be granted.
2 weeks time is allowed for us. I requested that learned AG list this matter 2 weeks. So as to enable her to seek instructions and file before the replies as compliance. Yes,
62,
2 weeks may be granted in.
2 weeks. Confirm, 2 weeks.
item number 63,
Complied with compliance affidavit is filed.
Compared with
64,
That's complied.
If you were compliant, liberty will be granted. 64.
You are 64.
I am 64. Yes. Here, your lordship kindly peruse. Annexure 3. Sorry, but I am 63.
63 has been complied with.
Compared to the liberty will be given.
Liberty.
Here, your lordship 64 and 65, my lord. Then the 10 petitioner before your lordship. They are the sweepers and the tax collector of the NAC, Court NAC, your lordship. After the filing the writ petition, there was specific direction was issued by this honorable court to comply the order, but it was not complied. Thereafter, a second contract petition was filed. Accordingly, the contemptor partly complied the order, but rest of the amount was not disclosed till now. That's why this is the third complaint, your lordship. They are the sweepers, your lordship. They are sweepers.
Let us see. Let me see the order.
My lord, I am placing your lordship. Annexure 3 kindly peruse. Page 17 and operating person, your lordship. I am placing your lordship. It is submitted by the Lender Council for the contemptor that the order passed by the Honorable Court will having a
No, you are reading which order? Where is that order? Just a minute.
Order?
Yes.
Page 18, your lordship. Page 18, order be passed.
Page 18.
18.
Page 18 is in contempt. Where is the writ order?
That takes 13.
Page 13, your lord.
Yes, what was the order?
Order, my lord.
To consider the representation.
Yes,
so whether your representation has been completed or
last chance, but last chance, dismiss it proper to dispose of the contempt petition with the direction of the object party contender to comply with the direction of the Honorable Court dated such and such, passed by this court in double petition number such and such. If the same has not been complied with, in the meantime, within a period of 6 weeks from the date of service of certified copy of this order, the petitioner, provided the operation of order judgment has not been stayed by higher forum, and file complaint report before the registry of this court within 1 week thereafter. And it is made clear that in the event of the order of this court, it is not given effect to within the time stipulated. Herein above, it will constitute to be deliberate violation of this court order.
What are you reading?
My lord, kindly peruse the annexure 3, your lordship. And
why should I see annexure 3? Let us come to the writ order. Which was passed. That is the order.
Writ petition order, your lordship.
Yes. So that was the direction was to consider your representation. Whether your representation.
Partly they are paid.
Then there is no question of.
Specifically, they mentioned your lordship.
All right.
Specifically.
All right. Where is the direction on your representation?
There is a direction.
Already it is 11, 2024 has been passed.
Here, your lordship.
Kindly peruse in the page 19, Your Lordship, last line.
Just a minute.
My lord.
Okay, this is your order.
This is the office whereby, my lord, if you, there is the table. For example, serial number 1, 5th pay arrear was paid.
Last version. Content page version, the content page.
7/11. My lord, 1 week time may be granted and file it in the form of a compliance affidavit.
File a compliance affidavit. I am not convinced. The direction was to consider your representation and dispose it off.
Considered.
They have considered that disposed of.
The part of the payment of
What payment was there? Was no direction for payment. Was there any direction for payment?
Yes, Your Lordship.
Where?
My lord, page number 19. Page number 19.
In the writ proceeding, there was any direction for payment.
No.
Was there any direction?
There is no.
Then,
but they have complied partly.
They have complied fully.
No, my lord. No, my lord.
One week time is around.
Clear, Your Lordship. Page number.
All right, I'll see.
1 week.
Council of hearing on AC requests adjournment to file a compliance affidavit. In the meanwhile, whatever is due, okay, we can clear.
My lord, after consideration of this order has been passed in 7/11.
No, in 7/11, you have admitted some amount payable. So you can pay that if that has all, that has.
I'll take instructions.
If they have paid the 5th area dues of all the petitioners, and the executive officer of Coercive NSC has informed that regarding release of ACP and MACP, a screening committee has been formed in Coercive NSC, and after scrutiny, the same shall be paid to the
Mr. Council, writ petition was filed
No,
on the 81st day, and thereafter you are raising everything in the contempt proceeding.
Sir, my lord, I'm placing your lordship. Report of the judicial. Go one line, my lord. 13 numbers of petition.
Sorry, I am not satisfied. Dismissal. 65.
65, sir.
Same.
66.
Order dated 5/2024. Operating personnel is my lord. Page 14. Paragraph 7. Direction was to file a detailed representation that will be considered so far as the gratuity of the petitioners are concerned.
Yes.
It's not the first time I think in the file of 2 weeks time.
4 weeks. 67.
My lord's order dated 16/4/2024 is not complied by the opposite parties by not giving the appointment under, wherein my lords were pleased to direct the opposite parties to consider my case under rehabilitation assistance scheme. My lord, in a clear and categorical term at page para 5, my lords have been pleased to direct them to consider my case within 2 months. And my lord, for my lord's kind knowledge, I beg to humbly submit that similar situated applicants have
already. So it's for the other side.
My lord, the opposite party.
No? Who is for the other side?
My lord, the my employer, that is the secretary of this central bank and president.
Ask the central cooperative bank.
I am not satisfied. The petitioner has alleged disobedience of an order of this court dated 16/4/2024, passed in WPC number 8959 of 2024. Stop. in the said petition, Registrar of Cooperative Societies, Odisha,
No, my lord, that is central.
Aska Central Cooperative Bank, Ganjam, and President Committee of Management Committee of Aska Central Cooperative Bank, Ganjam, were parties. The petitioner does not allege disobedience of the order by the registrar of the cooperative society.
No, my lord, I have second opposite parties, opposite parties who are employers.
He has grievance against the President Committee of Management Committee of ASCA.
My lord, as well as the secretary.
President Managing Committee of the Central Cooperative Bank, ASCA Central Cooperative Bank Limited, was not issued any notice before the said order dated 6/4/2024 was passed. So from such view of the matter, the officials of ASCA Central Cooperative Bank Limited cannot be held liable for contempt of court for any violation of the said order dated 16/4/2024. The contempt proceeding is dropped accordingly.
Item 68.
My lord, in this matter, in order to impress upon my lord's judicial conscience, I humbly beg to invite my lord's kind invite perusal of annexes 3 at page 17, wherein everything is first. That this is a second contempt petition, my lord. Page 17. Page 17, my lord, annexure 3.
No one appears. Which item?
68.
68, yes.
My lord, the petitioner made a humble approach to this honorable court seeking direction against the opposite parties for regularization of service. In WPC number,
what was the order?
My lord, order dated 14/7/2023 under annexure 1.
What is the direction?
But direction was to consider regularize my service.
All right. Regulation.
They preferred writ appeal under annexure 2.
Regularization where? You are working under whom?
My lord, Bhavani Patral Central Cooperative Bank Ltd.
All right. Interest. Same reason.
69.
Yes, Lord.
Oh,
In portion 2, order dated 69, I have instructions to appear. Local and appearance will be filed. Subject to Lordship would like to hear it, I can assist.
Yes. Order has been complied with or not?
Not complied. They have violated the same order. They filed a contempt application. Contempt application has been dismissed on merits.
Not merit.
That not on merit. Lordship will kindly see the certificate and earlier order.
Not on merit. I have already.
Kindly see this order. Like not on merit. The application was dismissed and the certificate appended to this contempt.
No. Let him finish. Let me say. I have disclosed the earlier contempt application, which was dismissed not on merit, due to non-providing of cohort order due to some technical ground that got dismissed. And
so have you mentioned this in your application? In your present application, you have mentioned that you have
mentioned. Mentioned. I have already in my certificate I have disclosed.
Where?
I have not successfully proved certificate.
All right, where have you mentioned? Where have you mentioned?
Page 3. Yes,
Well, let's say page 3. After contact of page 3. This matter, matter out of which this contempt petition arises was because this one group had CNPC number 2464 of 2024, which got dismissed on 9/5/2024. In this, or without any merit, due to unavoidable circumstances, due to defects of the visible copy within the stipulated period did not comply, so the case is dismissed. Only to that score, not on merit. Your Lordship,
This the order, your lordship's order.
Yes, I don't have any jurisdiction, it's answer. The petitioner in the present contempt application. There is disobedience of the court's order.
Your lordships, let me say regarding the question about tenability. Date may be fixed next day so that I will satisfy the
Disobedience of an order dated 23/6/2023 passed in WPC number 18348 of 2023. First off, the petitioner had earlier closed this court by filing contempt applications alleging disobedience of the same order, giving rise to CO and TC number 2464 of 2024 against the same contenders. First off, the said contempt petition was accordingly, the said contempt petition was dismissed by an order dated 9/5/2024 as according to this court, dismissed by this court, recording an opinion that the court dismissed the said contempt application, observing that it was not inclined to entertain the contempt petition. First off, this second contempt application alleging violation of the same order against the same contender is misconceived and is accordingly dismissed. Yes.
70.
Same set of contenders.
Item number 70.
Yeah, I am appearing for the Vice Chancellor, Central University, always compliant.
Compliant. Compliant. Please give him a copy.
Compliant 24/9/2024.
Please give him a copy.
Yes.
Compliant.
Proceed. Item 70.
70.
Sorry, item 71.
Contempt petition has been filed. Kindly come to Annex 1, page 10.
You are petitioner?
Yes, madam. And the order.
What?
Yes, 71.
Just a minute. Where is the order?
Order dated Annex 1, page 10. Order dated 4th January 2024.
What was the order?
Order clause 7. As an interim measure, it is directed that in the event the petitioner is continuing service.
All right. Writ petition is pending.
Pardon?
Whether the writ petition is
Yes,
pending.
it's
All right.
pending. It's pending, but
All right.
not listed till date. And the petitioner was
All right.
was not allowed to.
Why are you saying that it has become infraction?
This contempt, he is filing this contempt because the employee is thrown away from the service. That is why he is filing this contempt application. Now he is present and continue his job.
So you are continuing.
Yes, ma'am. He has been
So this is what he is saying, that this application has become infructuous.
Yes,
What is
no.
wrong in it?
He was disengaged from 25th April,
All right.
sorry, 25th, 4th,
Listen.
9,
Listen.
2024.
Just a minute.
And he was resumed duty on 7th October 2024. Since he has been joining the bank, the contempt petition may be disposed of as a draft.
Your lordship kindly have a glance to my reply application.
Of the parties submit that this contempt application has become infructuous. Stop. Contempt proceeding is dropped accordingly. Yes.
72.
Just now I have received a complaint that the report is granted.
Liberty. Drop liberty. Yes. Liberty.
Item 73.
In 73, my learned friend Mr. Prafulla Kumar Ratta, the senior advocate, was earlier appearing. I have been asked to conduct the case, so I could not get ready. Your Lordship may keep it to. May I pray Your Lordship may keep it to second week of December for.
Seek his, first of all, make a mention before him.
I had
Seek
told
his
that-
consent.
I had told him.
Your Lordship heard this matter in next time, so.
When?
The previous date, Mr.
When I don't try to keep anything in my mind beyond 1 week.
So here is a case below your Lordship can see.
No, but he is seeking adjournment. So
10 days time, Your Lordship.
10 days. Your Lordship fix up a date.
Before vacation, it
2
will be.
weeks. 2 weeks date fix. I'm giving you a date.
Your Lordship kindly observe that no further time. Because they're in this process they are taking time. Have 3 so-called affidavits.
Dismissal and counsel appearing on behalf of the and counsel has submitted that he has instructions to appear on behalf of the contender. On behalf of the contenders.
Alleged contempt.
Alleged contender. So he seeks adjournment to top. List this matter on 2 weeks. First off, the court expects that no further adjournment shall be sought in the present matter, which is pending since 2016.
Item note 74.
For your Lordship, kindly see the last order. That the submission was made. That petition has been filed. That is 266 of 2016 against the WPC number 18254 of 2012. The Lordship directed me to receive the notice. Well, in fact, Lordship kindly see that 266. It is not against that writ WPC. The contempt petitioners were also not made parties there. The Lordship may kindly see that petition is there. Neither it is against the WPC number 18254, nor the parties in the contempt petition are parties there. Last order, your submission is there.
Last submission.
Review is there in the list.
List, but it is reflected that it is disposed of case.
No. Where is the notice was issued?
Disposed of is WPC 18072.
My read was 18254. The contempt petitioners are also not made parties in the imbue petition. So there is no scope for appearing for anybody. And to file any objection, anything. So the direction is page 20, your Lordship may see, Annexure 1, page 20, in the contempt petition.
So this review petition has nothing to do with your case.
Yes, though we have not made any party.
Forget.
Your Lordship, there is a common judgment.
There is a common judgment. Therefore,
The common judgment has been challenged.
All right.
But we have not made parties there, so there is no question of let them make parties, then we can appear in the case. Otherwise, there is no scope for appearing in this case for whom? Unless we made parties in the review. Let them impede us so that we can appear and argue here, file objection, anything.
Where is the question of contempt then? Review application will be heard.
The review petition is not against us, your lordship may see common judgment. We have not been made party in the review. So, review also not stated against our writ petition.
Same order is you are releasing violation of the same order.
Yes, that is a common judgment. Several writ petitions, common judgment.
Common judgment, the first petitioner is Bimbasar Pradhan and he has been made as a party.
Yes.
They say that we have also opportunity. They can intervene in that matter.
How can they intervene? You can file review application in other writ petitions also.
Connected matter we have filed because the judgment covers all writ petitions.
Maybe, but he should also have a right.
But then we have to file as many as writ petition has filed. We have to file more.
You will have
Then we will file. Your lordship may direct us. We will file because in one case we have filed review and that will govern the entire case. That was your idea, my lord. But if they want that, we will file review petition in as many as all the writ petitions around England. The judgment is a common judgment.
Or else they have to impede all the writ petitioners.
How can they impede you in that?
They have stated that 266 is filing against me.
You have to understand new procedure.
They have to.
The petitioners allege disobedience of this court's order dated 1/12/2015 passed in WPC number 18254 of 2012. So stop. It was a common judgment delivered in how many applications?
They have placed 13, your lordship may see content petition, page 30. Page 13,
In
14.
petitions, including the petition filed by the petitioners. Also, the review application, which has been a review application has been filed, seeking review of the said common judgment and order. The Sovereign Council, appearing on behalf of the petitioners has submitted that they have not been implemented as party in the said review application. First off, it's very difficult. Either you file review application in all the cases, otherwise,
yes.
And after 6 years, how can you file the review?
Limitation will be problem.
Do whatever you want. Complicate simple things. Just the matters. 4 weeks.
75.
Four weeks.
The order has been complied.
My lord, in this order, my lord, Honorable Court pass order to give a appointment befitting qualification. My lord, thereafter they file a WA and after unsuccessful WA, they file a SLP. SLP, my lord, Honorable Apex Court pass order take compensation whatever he spent the service time period of the service, he compensation 15 lakhs. I have received my lord. But I have not get job, my lord. As a first point of this order, my lord, we are not intending.
See, Mr. Counsel,
My lord.
now final order has been passed by the Supreme Court. If there is any violation, then it is violation of the Supreme Court's order. So no contempt can be maintained.
I have also filed a case before the larger bench, my lord, in Supreme Court, my lord. In Supreme Court, I have filed a larger bench, my lord.
Any court's order violation, in my considered opinion, since the petitioner has been paid a sum of rupees 15 lakhs in terms of the Supreme Court's order passed in SLP. Do you have a copy?
LP number, my lord. Number 15789, 2019.
No case of violation of this court's order dated so and so is made out. Contempt proceeding is dropped. Yes.
76.
Pardon, my lord. My lord, can you see order dated 26/7/2004, order number 8. 26/7/2024.
Yes.
Here, your lordship directed a additional government council to take instruction in question recovery the from concerned insurance company and disbursing the petition. In reply of your lordship order, they have filed 3 affidavits. One affidavit in dated 1/8/2004 of para 10, you will see what is stated. Affidavit dated 1/8/2024. Last affidavit, he stated that after order was passed, the insurance company deposited the said amount for payment of claimant as per case record and available of document in case record.
Yes.
Petition already received all total they have stated they received 4,16,797. In this affidavit, they have stated that amount is was. But you lordship see how their peculiar case in 17/1/2023 said contempt find another affidavit in that regard. At para 15, he stated that you lordship can see that para 15.
Yes.
He stated that after order was passed, the insurance company paid the same amount to the claimant, and in between during the pendency of proceeding, and the petition have already received periodically 5,18,246 rupees, 4,53,474, 3,04,200, all total 12,75,930. In this affidavit, they have stated that they have one affidavit 4 lakh is it, and another first stroke of the affidavit dated 12/10/2022. He stated peculiar. What your lordship observe? He stated that they cannot understand. They beg. They stated that delay of proceeding, they have not ever recovered any amount. Now, what amount laying of the petitioner, I file a rejoinder affidavit, I give a calculation sheet. Your lordship by para 15 of my rejoinder affidavit. In 3 cases, I have given what amount laying as per term of order dated 31/2008. But honorable single judge passed the term of order dated 30, and that commission has to recover. That I have given a detailed calculation sheet. But they are not sure what is my amount, what they have deposited. Frequently, different times, they are not coming this board in clean hand. So my only assumption, how can I get my compensation out? Nothing more, my lord. So your lordship, they are direct to pay my amount, and they have taken the wrong step. So your lordship passed a reasonable order, poor man, nothing to say. That is my case.
You have made computation.
I have made a computation. In my counter affidavit,
Do they agree? Do they agree with your computation?
No, they have not agreed. They have filed different affidavit saying that this amount, they are not sure what is my amount. They have not given any computation.
If they are not sure, if they are not sure, then their intention, the violation is not intentional because they are not sure.
The order is very clear. Single judge order.
See, this is your stand that they are not sure.
No, as their affidavit,
they are indecisive. They are unable. See, this is contempt is an offense. So whether what they are doing, they don't know. Therefore, no contempt is made out. Your submission
how can get my money? I cannot change the fruit of the judgment.
You want money? How much money do you want? And whether this is what you have calculated.
Yes, I have given calculation.
But that calculation was not done by the High Court. By the High Court.
Let them direct to. If your lordship satisfied Annexure 1, remand the matter to commissioner.
Annexure 1.
Annexure 1, wrong order they have passed. Annexure 1.
Have you filed any application for setting aside an order?
No, I only filed contempt because that order is the
contempt. How can I set aside the order in a contempt?
No. I suggest if your lordship give chance to commissioner to reconsider the order of honorable appellate single judge, the matter would have been finalized. Insurance company will come and they give their.
There is the question of issuing further direction in the contempt proceeding. Yes. What is this dispute about, Mr.?
My instruction that the further affidavit was filed, and in further affidavit, Annexure A says that everything, every amount has been paid, but they say that they are disputing the payment. My lord, so far as rejoinder, they are mentioning rejoinder, they have not served copy. What document their computation they have made? I will seek instruction on that rejoinder, my lord.
Serve a copy.
I have served. Yes, I will serve another copy. You also, I will serve a place copy. If he don't accept that is not received, then I will
there is no endorsement. There is no copy available.
Yes, I will serve place copy.
Get a copy of the rejoinder affidavit that to have been filed on behalf of the Sydney, filed on behalf of the petitioner, be served on the AGA by Monday.
Yes.
Do it by Monday. Let's matter on next Friday. In the meanwhile, please.
The 3 cases, 1, 2, 3, 92 to 9, same cause of action.
All right.
Another connector matter.
77.
Yes.
Item 77.
No implementation. This is this application. Yes.
Item 78.
When judgment order has been complied with, the compliance affidavit.
Compliance affidavit filing.
Complied with.
Copy will serve.
79.
79 also, my lord,
Compliance.
Next, 80.
This Mr. Jackson is the conducting counsel, but today he informed me to pay for adjournment because he one of his family members died. So let it come on next week.
Petitioner, next Friday. Yes.
81.
Kindly see the order dated 3/5/2024.
Yes.
Here, my lord, the petitioner
Which order?
3/5/2024 passed in the present petition of Contempt.
Yes, where is the order?
3/5/2024.
No, that I have seen.
Yes.
Where is the order?
The order passed by the single judge, Honorable Single Judge, my lord. Your lordship, kindly see the running page 46. This court below this petitioner is a national, international acute scientific, computer science professor. He has been harassed like anything. Even today, an affidavit which is said to have been shown on September is given to me in the court now, just 10 minutes back. Yet they have filed another false affidavit, incorrect affidavit, regarding compliance of the order, though they have not complied. They have been directed to pay the pensioner. The retirement benefit means all pension, the entire pension, which is entitled under the law, that means full pension, with other leave, salary, gratuity, etc. In the reply, in the affidavit today they have served, which is shown on 20th September 2024, the lordship kindly see, they have stated that petitioner has complied, the opposite party university is complied by granting provisional pension. That is even 1/10 of the pension which I am entitled. Because now I am entitled more than 1 lakh pension. They have calculated at the rate of some 8,000 or something and giving 12,000 something. And calculating that 12,000 area they have given, and they are saying, giving a incorrect affidavit before this honorable court. And now my wife is ailing. My mother is now sometime in 1990 is a
No, where is which part of the direction has not been implemented?
My lord, that is the 46 I said, man. I thought your lordship was gone.
46, read it. Which direction?
Your lordship, can see last 4 lines. Therefore, in the interest of justice and equity and fair play, this court is of the considered view that the impugned order annexure 7, dated such and such as observed above, cannot sustain in the law and liable to be set aside. And according to the same is set aside. That is the impugned order. The
impugned order has been set aside.
Thereafter, nextly, consequently, the petitioner be entitled to get all consequential service benefits as due and admissible in law, which shall be computed by the university authorities within a period of 3 months, so as to settle the issue for all the time.
So that has to be computed by them. You cannot say that you are entitled for this much.
No, I don't say that. They have not computed till today.
They will have.
Thereafter, your lordship can see the matter was placed before this honorable court on 3/5/2024. And the bill 3/5/24, your lordship can see, Lord Counsel appearing for the opposite party number 1 to contend that basing on the order passed by this court, though unutilized leave, salary and gratuity has been released, but pension is due and admissible has not yet been sanctioned and released. It is further contended that opposite parties shall take effective steps for sanction of pension and release the same in the meantime, as requested such and such put up such.
So was there any?
Then your lordship can see the affidavit filed today.
Mr. Please tell me
Madam.
whether there was any mention of pension.
Yes.
In the order.
The service benefit, madam.
Service benefits. Service benefits as admissible. So let us see, yes, what is the
and that is what on the basis of that hearing, your lordship can see that 3/5/2024 effective state for
sanction of pension. We must be clear on one point. The order of the writ court cannot be modified in the contempt proceeding. All right. So we have to refer to the order passed in the writ proceeding always for all purposes. So which part, therefore, I was insisting that which part of the order. Yes, what is your stand, Mr.
Mr. Can I just say my affidavit?
Yes.
In the meantime, my lord, in fact, the unutilized leaves, that is 60,000 rupees already paid, gratuity already paid, and also arrear pension 17 lakhs and 32,000 already paid. And also, can I say last paragraph, for other things, my lord, he is to get some undertaking has to apply the, because of the entire pension matters in my paragraph, in page 13, and the undertaking is to give. So he has not given the undertaking despite all request money is not coming to the university. If he come to the university, then he will fill up the form, then whatever amount will be paid.
Where is that?
No, these are all, I've been going, I'm staying at Bhubaneswar. Time and again, I'm going, and I'm never called. They have said orally, they have not issued any letter. In fact, they sent a letter to my department, which I left 20 years back. And I got it by going to the department, which they should have sent me by representation, everything I am giving during after my date of superannuation, by giving my address.
You go tomorrow,
But we are here. You can do it.
No, it is all ballot. This is an incorrect statement. Lordship always
calculation.
These are your Lordship.
By what time?
Your Lordship can see. They have not said the pension is given. They have not. Your Lordship can see paragraph 5 of their so-called affidavit, compliance affidavit. This is not a compliance affidavit. The provisional pension they themselves say. So my full pension is more than 1 lakh per month is not yet given.
I have to fill up the form so that we get no problem.
Who refuses? They never called this.
You go tomorrow, no problem.
Do it.
This whole point, your Lordship may fix up I will go within a day or 2 or by Monday, because he himself is yelling, his hands has become numb. His mother is not able to go. In 96 is the bedridden. His wife is also due to the accident. He is suffering.
I cannot go into such details.
No. I'm not. The whole point is that I have never called because of this thing. They are without any affidavit. Also, they are submitting this beyond the affidavit.
He personally takes the university.
The affidavit, which has been filed on behalf of the opposite parties, it has been stated that the petitioner has been asked to fill up.
No matter, it is not stated in the affidavit, with all respect. They have not stated so. Affidavit will also kindly see 2 pages.
The petitioner shall be paid the pension that sanction shall be met for payment of pension once the petitioner submits a duly filled up form in form of application bracketed annexure 3/1. Stop. Counsel for the petitioner states that the petitioner shall submit the said form
imported
by
within a week,
Monday. Stop. List this case on Friday. Within first 5 cases. Yes. In the meanwhile, if that is done, please.
I will go as soon as do
it. I'll see to it that it is.
The entire, the whole family,
see.
82.
Substantial. More than 1 lakh, they paid 10,000 rupees.
All right.
17 lakhs of getting.
Item number 82.
And that more than crore, that's with all respect, what is happening in the state functionary, I just failed to understand.
Grievances Act is 12 months. And it is specific order to that. Be that adjustment, since the petitions are entitled to the benefit as per the order of the tribunal being confirmed by this court, and further there is already determination of the arrear by the annexure 4, this court in disposal of the writ petition direct the director
Elementary Education Orissa opposite part number 2 to release the arrear in favor of the petitioner within a period of 1.5 months from the date of the communication of a copy this order by the petitioner. It is however made clear that
Yes,
if the opposite parties
yes, all right, we have seen.
My lord, writ appeal number 1863/2024 is pending.
Yes.
My lord.
Retrospective.
My lord, I may be permitted to one.
You should not be permitted to
My
say.
lord, what is happened?
Writ appeal is pending, it shall be finally decided.
I only intimate that two petitioners are filing. One petitioner is released the arrear deed. Out of the 6, all are getting except me.
Maybe.
They have filed review. Review is dismissed.
Maybe. I have seen the order.
Man. How they are
83.
discriminating me on what ground I could not understand.
83 is compliant.
Submit the compliance capital.
Complied with.
Item number 84.
84 Lordship, grant me 1 week time.
And ETA takes adjournment for a week to report compliance of this court's order, violation of which has been released.
85.
This is relating to the release of GPS and final pension, Miller. I'm filing the affidavit, Miller. It is on the process now because he was sorting under 5 stations, Miller. Now, all documents we have received from 3 stations, only 2 stations are left. Now they are on the process.
So how much time will you take?
2 weeks time.
2 weeks time take for what?
To release the GPF amount and final pension.
So no more than two weeks.
Yes.
Otherwise, I will initiate contempt proceeding.
Well,
Because this is a 2020 matter. This is 2020 matter, and we are in 2024. It's a gross case. The gross case of contempt. Let the engineer in chief be here. This is 2021 matter and the GPF. Just think of his own money is lying in the account. And counsel appearing on behalf of the opposing parties submits that the petitioner was posted at various stations and steps are being taken to get the details of his GPF deposits from all such stations. First off, he submit that it will take 2 weeks, 2 weeks time. No. 2 weeks further time to get all the details. So when did he retire? When did he retire? When did you retire?
Ballot, since 31/3/2011. 31/3/2011.
And when was the order passed?
Ballot, page 8, you not seen my
2/6/2020.
What was the post which you were holding?
Ballot, junior engineer electrical.
But why this amount remained pending for so long?
Despite ballot repeated approach to the authorities, ballot, they did not release. On the ground that your
So this is 2 weeks, first 5 cases. First off, if by the set date, the GPF amount is not credited in the account of the petitioner, and the pension is yet to be sanctioned.
Final pension is yet to be sanctioned.
And pension as admissible to the petitioner is not sanctioned. Comma, the engineer in chief, which place?
Open number 3, the engineer in chief come principal chief electrical inspector, madam.
Shall be required to be opposite part number
3, madam.
shall be opposite part number 3 is engineer in chief posted shall be required to be personally present in court when the court shall consider framing of charge of contempt of court against him. Yes.
Obliged.
Item 86.
The order dated 4/11/2016 matter have not been complied, and despite dismissal SLP, to dismiss SLP, the opinion number 2 is to comply the order. Instead of complying the order, he requested the government time and again to give instruction. Kindly see their affidavit. Affidavit will kindly see the collector para page 4 para 11. So after dismissal SLP, I requested the government to issue necessary instruction. Because government not taking action, I am unable to do. And the order is to comply by collector, because I am junior clerk. Regulation order is a regulation service. And not by the collector. Time and again, respect this SLP. Collector director requested the government to issue the instruction. No instruction. 2008-16, I am subsumed.
Yes.
The SLP was dismissed on 10/5/2024. Thereafter, it is under process. I have already obtained instructions.
Within 1 year, you can comply with the order.
They have prayed for 4 weeks time.
I will not give you 4 weeks, 2 weeks maximum. As requested by learned AGA, discuss matter on 2 weeks. First off, in the meanwhile, if the collector fails to comply with the this court's order, Collector Sambalpur fails to comply with the court's order, he shall be required to be personally present in court on such and such day on 10:30. सबका जहाँ पे नहीं है personal appearance 10:30.
87.
87 order is complied.
Item 88.
88 order is complied.
89.
Was not filed again. Non-compliance of order dated 24/11/2020 and so was not filed matter of relevant person order number 6 annexure 1 matter. Considering the limitation and grievance of petition, this court without expressing any option on the merit of case dispose of writ application directing to opposite party number 1 to consider the representation filed by the petitioners under annexure 12 matter within a period of 3 months.
Yes.
2 weeks time.
Oh no, 1 week. Chief Secretary was asked to ensure that all the representations are disposed of.
1 week.
List this matter on 1 week, so as to enable and AGA to seek instructions as to whether the court's order directing the opposite parties to dispose of the petitioner's representation has been complied with or not. Yes.
Item 90.
90 is complied.
Complied with.
90. That's right, 90. They filed a complaint report employing by false affidavit. False affidavit. I have filed reply. Your Lordship directed.
Let me see the order first.
Your Lordship directed.
Let me see the order first. Right. Where is the order?
Page 3. The order was quoted.
You have quoted.
Taking into consideration the submission made by the land counsel for the parties and without expressing any opinion in the merits of the court of the considered opinion that since a recall petition under Annexure 5 is pending before the Tahsildar Jasura, Sadar Tahsil, opposite party number 1 to take a decision on the same in accordance with law. Accordingly, this court disposed of the writ application with a direction to the Tahsildar Jharsuguda, Sadar, opposite party number 1, to take a decision on the petition dated 30/7/2020, that is recall petition annexure 5, as expeditiously as possible, preferably within a period of 2 months. From the date of filing an authenticated copy of the order giving opportunity of hearing to the parties. This direction was given. Till today, the order was no order passed recalling that petition.
No, there was no direction. There was no, the direction was to pass an order on your recall application. That's all.
No order passed till today.
All right.
And they have filed a complaint affidavit enclosing a false affidavit stating that it has been complied. Thereafter, the matter is still pending. I have filed a reply, Your Lordship kindly see. Annexer.
Just a minute.
Annexer complaints affidavit. Your Lordship kindly see Annexer B.
Yes.
Page 7.
Yes.
Dated 27/1/2021.
Yes.
Stating the order has been complied. But the matter thereafter, Millard, Your Lordship kindly see my reply that he has issued notice for hearing of the case, of the same case, Millard. And thereafter, Annexer 4, Millard, Your Lordship kindly see the 4. Page 8 of the complaint. That WPC number so-and-so 2079 of 2000 fixed to 29/1/2022 for hearing. The order complaints Millard 29/1/2021. They said it has been disposed of. But no such order passed, no records available, and subsequently, Millard, when I pursued the matter, they have issued.
See, according to them, please, according to them,
yes.
This order has been passed 27/1/2021 on your recall application.
Yes.
This is incorrect.
Incorrect. That is false.
Just a minute. On 27/1/2021, no order was passed.
No order was passed. I have filed, Millard, the reply affidavit stating, enclosing the documents, the case is still pending. Be very unfun. Normally, Millard, once they say it is complied, normally everybody will believe that he has been complied. But he has ventured to file an affidavit stating that he has complied the affidavit enclosing the order. But no such order, you will also call for the record. No such order is available. No
There is
order passed.
There is no order dated 27/1/2021.
That is evident, Millard, from my reply affidavit, Annexer Millard 4 and 6.
Is it correct, Mr. Counsel?
And last time also I have pointed out and decided.
Take instruction on this document. Because they have filed an affidavit.
It is very serious, Millard. They say and signed an order before your Lordship saying that we have complied and annexed the order dated 27/1/2021. You will also call for the record and see. And if that is compliant, Millard, again hearing was fixed on notice was issued on 19/1/2022, fixing the date 29/1/2022, one notice. Another notice issued, Millard, 10/8/2022, fixing the date 26/8/2022. That is page 13 and page 8.
This court by an order dated and so disposed of a writ petition filed by the petitioner with a direction to Tahsildar Jharsuguda to dispose of a recall petition filed by the petitioner on 3/2/2020. First off, a reply affidavit has been filed wherein it has been stated that in compliance of the said order, the petitioner's application for recall has been dismissed by an order dated 27/1/2021, passed by Tahsildar Jharsuguda. Stop. A copy of the said order has been order dated 27/1/2021 has been brought on record by way of annexure B to the compliance affidavit. Stop. A reply next. A reply has been filed to the said compliance affidavit disputing the averment made in the said affidavit, and asserting that no such order has ever been passed by Tahsildar on 27/1/2021. Stop. Let learned AGA representing the contemners produce the records of so and so, records of the concerned file containing the order dated 27/1/2021 on 2 weeks.
Anti-record below, subsequently issued notice, anti-record, that case 2801. Mutation case 2801,
Of
anti-record.
mutation case 28. Mutation case is correct?
That is mentioned in the order. The notice it in order also it is mentioned.
We'll see. Yes.
91.
My lord, I am for the petitioner manual 91, not complied court order.
Yes.
My lord, annexure 10, page number 10, my lord. Annexure 2, page number 10. Taking into submission made by the Learned Counsel for the parties, the writ petition is disposed of with a direction that in the event of petitioner move application for early disposal remand case number at the stating ground therein, this said application shall be disposed of within a period of 2 weeks from the date of filing of the said application, along with a certified copy of this order, and follow-up action shall be taken by the authority for expeditiously.
Yes, please wait.
They are directed to file the certified copy of this order along with an application for early hearing. In the content petition, they have not taken any averment whether they have filed that order and also the application for early hearing. They have not taken any averment when that order was communicated. Only they have taken the averment at paragraph 4 of the content application that order copy was communicated from the office of the Learned Advocate General. And they are silent whether they filed an application for early hearing or not. But my lord, so far my instruction is concerned, now the consolidation officer is proceeding with the hearing, and next date is fixed to 7/12/2024.
Yes. So where have you stated that you complied with the order? Where have you stated?
My lord, disposal of the case of High Court. Present petitioner file High Court order with an application copy before Srimati Niharika Naik, consultation officer cum additional collector Puri Charinola, Puri on dated 1/2/2020. But till date, contemptor has violated the order of High Court. The said order copy of WPC numbers 1343/20 in annexed with annexure 2. My lord, I have filed on 1/2/2020. Copy of from net copy, my lord.
2020. Yes, I can understand. Yes. So that statement is there.
Now the proceeding with the hearing, like date is fixed to 7/12/2024, and the previous date he did not appear for the consideration officer. They may
My
appeal.
lord, previous date was due to cyclone closed, my lord. 24/11 thila.
All right, granting 3 weeks time.
My lord, obliged.
Matter on 3 weeks. Okay. What is the date fixed?
My lord, 7th December.
7/12/2020.
7/12.
It's 20th. It's 20th.
20th December. It will come on 20th.
My lord.
20th. Let so-called reply be filed. So-called reply / compliance affidavit be filed on behalf of the opposite parties in the meanwhile.
Item 92.
Item number 91, 93, let's see column. Next week.
Next week, as requested.
93.
Let 92. 92.
92.
92. SLP.
1 week.
Well,
Next week.
93.
93 also.
93 I am appearing in VC, my lord.
Yes, next week, Mr. Tam.
My lord, published.
94.
For SL dismissed on 25, 10th on 24.
So how do you get your all the SLPs dismissed? All right. So yes,
My lord's instructions have been sent to the Director Secondary Education to implement the order. 4 weeks time may be granted.
In some cases,
All right.
man has retired since long. In some cases, on 20th December.
4 weeks
3 weeks, I only for 3 weeks because before vacation, I can't take out.
vacation.
Before vacation, that only clear. On 20th, madam.
20th. Right. It is stated by Learned Counsel for the petitioner that an SLP preferred against SLP arising out of the court's order violation of which has been alleged in the present contempt application has been dismissed. Despite that, this court's order has not been complied with. ASC representing the opposite parties submits that steps are being taken for compliance of this court's order. So place this matter on 20th. As to enable an ASC to seek instruction and file so-called reply / compliance affidavit.
Item number 95.
Your Lordship, on behalf of my learned senior, I pray for a short adjournment.
Yes. Complied with.
Well, its compliance affidavit will be filed in this matter, but thereafter, as if your Lordship is not satisfied with the compliance.
All right. Only as requested on behalf.
Item 96.
This is partly complied only by reinstating the petition so far as the financial and the other consequent services.
So their intention is not to violate.
I know.
Their intention is not to disobey this court's order.
Lordship, they are disobeying because
they have partly complied with.
Partly only by reinstating the petition. So far as the other benefit, financial and other consequential benefits concerned.
So what is that? Where is the order?
The Lordship, the Lordship had quoted that in the last order, 4/10/2024.
Yes.
This non-convenience order of D8/2016.
Yes,
Second,
madam.
But instructions are there that financial benefits till the rejoining they would be notional. As she is not notional, financial benefits will be given to her. There has been instructions as well.
The Lordship may kindly see the judgment.
The difficulty, Mr. Counsel, is that it says all consequential service and financial benefits. They have given you.
So far as the financial, they have categorically stated that financial benefit has to be extended.
Financial benefits? What financial benefits? There should have been clearly mentioned that you will be entitled for back wages. And this is what the Supreme Court says.
Your Lordship, may kindly see page 12 of my contempt petition, the operative portion of the order.
Operative portion, yes. Page?
Page 12 of my contempt petition.
Here.
Accordingly, the impugned order is quashed, not being relatable to the applicant. The respondent authorities are directed to take the applicant back in service forthwith and extend all consequential service and financial benefits within a period of 2 months from the date of receipt of the copy of this order.
So according to them, it's not clear. According to them, you are entitled for this much only, which they have given. So if you are aggrieved by said decision, you can challenge that. It's not clear. It could have been mentioned in the order that you are entitled for all the back wages.
This is the new thing they are coming up with. Your Lordship, may kindly see the show cause affidavit. What they have admitted.
Yes.
Page 5. Paragraph number 7. That it is respectfully submitted that admittedly the learned tribunal, by its order dated 3/8/2016, while quashing the termination order, directed the authorities to take back the petitioner in service forthwith and extend all consequential service and financial benefits. And the said order was passed on 3/8/2016. And by the time the said order was passed, the NPS has already been come into force with effect from 1/1/2005. And it is also a fact that even though the petition was appointed in the year 99 and continued till a termination that is till 8/10/2001, but during the service from 99 to 2001, GPF account petition has not been opened. Therefore, in view of introduction of NPS, it is not possible to open the GPF account as claimed by petitioner, for which the petitioner was requested to submit necessary documents while dated 27/5/2022. And though the petitioner, in response to the letter issued by the block education officer verbally, submitted necessary documents, but has not furnished the OTP regarding payment of arrear financial benefits. And such he has not.
Counsel, better you file an application, file a writ application and get all those aspects resolved. Otherwise, it is very, very difficult. They are taking some stand. So in contempt jurisdiction, I cannot decide this. They are raising some dispute.
Is that changing the stand? Therefore, I was drawing the watch attention.
This affidavit is dated 26/2024. On 28/6/2024, notional financial benefit has been granted to the petitioner, decided to be granted to the petitioner. There's a letter.
So you will have to assail everything. Otherwise, just keeping the contempt matter pending is not going to help you in any way.
Correcting the stand, therefore, I wanted to draw your lordship attention to this. Because they themselves admit that.
See, I cannot advise
they are ready to pay me the area financial benefits. But now they are saying that they are only extending me the notional benefits.
Liberty and challenge that. The petitioner has alleged disobedience of this court's order dated 3/8/2016, passed by Odisha Administrative Tribunal in OA number 1834 bracketed C of 2008, operative portion of which reads as under. Accordingly, that order is quoted in the order dated 4/10/2020. Stop. Next, Mr. S. Sekhar, learned counsel appearing on behalf of the petitioner has submitted that in the light of said order passed by the tribunal, the petitioner has been taken back in service but has not been granted consequential service and financial benefits as directed by this court. Stop. Next, learned ASC appearing on behalf of the opposite parties, on the other hand, has submitted that a decision has been taken to grant the petitioner notional financial benefit consequent upon the petitioner's reinstatement in the light of the aforesaid order of the tribunal dated T8/2016. So stop. When counsel appearing on behalf of the petitioner has drawn this court's attention to the stand which the opposite parties have taken in their so-called reply dealing with the petitioner's claim for opening of GPF account and his entitlement to pension under the pension scheme, old pension scheme. So stop. Next. The issues which are being raised by the petitioner, keeping in mind the fact that the opposite parties have taken a decision as regards the petitioner's claim for financial benefit, in my opinion, such disputes cannot be gone into in a proceeding under the Contempt of Courts Act. First off, the action on the part of the opposite parties cannot be treated to be deliberate disobedience of this court's order. So stop. In such view of the matter, the contempt proceeding is dropped with an observation. Dropped. So stop. Goes without saying that the petitioner shall be at liberty to question the legality of the decision taken by the opposite parties on the point of grant of due consequential and other service benefits arising out of washing off the order of termination and his subsequent reinstatement in terms of this court's order dated 3/8. What is that?
3/8/2016.
3/8/2000. No. 3/8/2016.
Yes, sir.
3/8/2016. Austin OA number. Yes.
1384C of 2003.
Yes.
1834C of 2003.
97.
Copy of the decision will be some.
Please.
97.
Yes, madam. Otherwise, they will just keep on arguing the contempt matter and you cannot get anything in this proceeding.
Lordship,
Yes,
can you
check.
have a glance to page number 22?
My lord,
That's the order.
7 has been complied.
Here also exactly like the previous case, madam. I am required to be, the petitioner is required to be considered antedated promotion with effect from 89. But they have extended it from 2001. Exactly like the previous case. Your lordship may give me liberty to agitate it.
The
Order is at page 22 of the content application.
dated so and so appears to have been substantially complied with. No case of intentional disobedience of this court's order is made out. Then counsel appearing on behalf of the petitioner has submitted that the refusal on the part of the opposite parties to give the petitioner a retrospective promotion
To the post of senior draftsman.
to the post of senior craftsman
in the year 18.
Which
Is required to be considered.
from the year 1989
Instead, they have extended it from
Has-
2001.
not been duly considered. And instead, the petitioner has been granted such promotion with effect from 2001. Stop. Such dispute, in the court's opinion, cannot be gone into and adjudicated upon in a contempt proceeding. Stop. The contempt proceeding is accordingly dropped with a liberty to the petitioner to question the decision, question the legality of the decision taken on behalf of the opposite party on the point of date of grant of promotion to the petitioner. Yes,
98.
With the liberty.
liberty that has
Matter may be disposed that if dismissal.
no dropped.
98 is also
Speaking order
Same.
has been passed.
Same,
Speaking
and
order.
liberty may be granted.
Liberty.
Challenge.
Liberty.
99.
Yes, ma'am.
99.
Order dated 8/9/2021, partly complied, my lord. So far as other grievance of the petitioner as per the order of the Honorable High Court, the petitioner filed the comprehensive representation before the opposite party. And the opposite party partly complied, but other grievance, my lord, till date not comply. Your lordship may kindly say.
Whether order has been passed or not,
Order has been passed.
Order has been passed.
and the order has been fully complied with.
My lord,
You can see there was direction to consider your representation and pass a reasoned order. That order has been passed. Then
my lord, so far as other grievance still date not comply.
other grievance, there is no such order.
My lord, this matter may be passed over. I'll just check the document.
My lord, liberty may be given.
No, she is seeking adjournment. See,
Has other grievance has filed the writ petition.
I have to just cross check with the.
all right. Next week, as requested by Learned AAC, list this matter on next week.
And copy may be.
Next week.
Item 100.
My lord, speaking order has been passed.
Bandwidth.
Item 101.
SLP is pending, my lords. SLP number 4815/2020.
Yes.
Item 102.
Non-compliance of the order dated 4/4/2022. And on dated 5/8/2024.
What is the order?
24. This Honorable Court issued notice to the Tahsildar.
What is the order?
I see, my lord, Annex 1, page 8.
What is the order?
Order, my lord. In view of such written instruction, nothing remains to adjudicate the writ petition. The petitioner may collect the copy of ROR from the office of the Tahsildar Sadar Kotak by making proper application. I have applied application.
Where is that?
Page 10 and 11.
Where is that?
Page 10 and 11. Order, my lord. Page 8. This matter is taken up through hybrid mode. Petitioner in this writ petition prays for a direction to issue ROR in his name pursuant to the order in RP number 697 of 2014.
So there was no order.
My lord.
There was no order.
Order टा हमारा जो थिला माने order whatever the order the माने page 9 में my lord kindly see in view of such written instruction the petitioner may collect the copy of ROR and I have not received ROR.
Did you go and collect?
Only my.
Did you make an attempt to collect?
Yes, my lord. I have given and my several attempts.
Yes, madam.
Application I have given page 10 and 11.
As per para 4, the petitioner have to go and collect the ROR, but on next page, page number 10, he has requested the Tahsildar to comply with the order of the court.
So you go and take ARR from there.
There's no government as to.
Direction to given to the Tahsildar.
No, direction was to you. Petitioner may collect copy of the IOR, copy of the ROR from the office of Tahsildar.
ROR from the office of the Tahsildar.
After making proper application.
So did you make proper application?
Yes, application.
Where is that? Where is that application?
Page 10 and 11.
Seek instructions. Why is this matter on? Only so as to enable and ASC to seek instructions as regards compliance of this court's order.
103.
103 SLP diary number 2798/24 is pending.
SLP.
The matter is pending for the last 2.5 years. The order was passed on 15/7/2022.
So the order.
Your Lordship, order is annexure 1, page 8, that to consider the case of the petitioner for appointment under the Rehabilitation Assistance Scheme in terms of the provisions of Odisha Civil Services Rehabilitation Assistance Rules to 1990 as amended in 2016. And thereafter the state preferred an appeal, and appeal was also disposed of in favor of the petitioners.
Where is that order?
That order, they preferred an appeal in WA number 1318 of 2023, where it was disposed of. Here it was directed that at this stage it is contended that the case of the appellants are covered by the judgment of this court in the case of State of Odisha and others versus Bindu Sagar Samantra, the batch case, and disposed of on 25/9/2023.
You will have to wait.
In that case, my lord, especially it was made clear that no further extension of time was given. Only 4 months was given for compliance of this order. 25/9/2023, the order was passed by this honorable court. And specifically, it was mentioned in the judgment that no further time will be extended.
No, but because SLP is pending,
Lordship.
and
We have not received any notice.
SLP.
104.
Rule of April 23 is not yet compliant. Order is annexure 1. It starts from page 11. The operating partner at page 18. 6 line from bottom line. While holding so, this court is inclined to quash the impugned order dated 17/9/19. So passed in GIA case number 347 of 18. On annexure 4 to the appeal and quash.
Where is the order?
Page 18, where is the operating part?
Page 18. What?
Page 18.
What is your? Was the impugned order? Yes.
The order of the Warrant Tribunal rejecting the case of the petitioners which are challenged before the
Which tribunal?
State Education Tribunal, claiming granting advance. By filing a GIA case, that is a granting aid case was registered. Two granting aid case was filed by 2 set of employees of the institution, same institution, and one benefit has been extended to those persons after dismissal of the SLP. And petitioner case was rejected by the tribunal. That was challenged before this honorable court, and that was quashed, and direction was given to release the same benefit as has given to other employees of that institution. And my lord, kindly see the order dated 22nd.
Just a minute.
Because direction has been issued to the Director Secondary Education to comply with this order, 4 weeks time may be granted.
SLP has been dismissed. My lord, kindly see the order dated 22nd March and 3rd of May. 3rd of May order, my lord. My lord directed to, they took time to, since process has been started after dismissal of the SLP on 2nd of March. On
Referring to which order?
order 3rd of May, man. And that, prior to that, 22nd March also. It was brought to the
1 week, madam.
That's 2 weeks.
Because of the on 3/5/2024 itself, time was granted.
my
So we are in November. Doesn't look good. Unless this matter this contempt application was earlier taken up on 3/5/2024. And a submission was made on behalf of the opposite party that the steps were being taken to implement this court's order. Till date, the court's order has not been complied with. This case on 1 week.
Item 105.
Yes. One. No one appears on behalf of the petitioner. This matter next week.
Item 106.
Non-comprehensive order dated 3/3/2023 matter. Lordship kind of glance page 17.
Page 7.
Page 17 matter.
17.
The operating portion of the order. Here it is.
Yes.
In view of such admission made by the authorities of UT in Annex 4 and 5, the stand taken by the government that the government has no role to play with regard to action to be taken by the university being an autonomous institution. This court, by disclosing the real petition, direct the authority of opposite partner 1 and 2 to take a decision on the claim of the petitioner for their regulation, basing on the decision of honorable appellate court in case of such and such. In para 13, it is also directed that the opposite party number 1 and 2, while considering the claim, shall follow their own stand as taken in Annex 4 and 4. The entire exercise be completed within a period of 2 months from the date of respective order. This order has been challenged before the Honorable Appellate Court, and Honorable Appellate Court dismissed the SLP. Kind of glass flag P, my lord. The order.
Yes.
Thereafter, no action has been taken for regulation of the petitioner service. Both the state government as well as the way to authority approached Honorable Supreme Court, and both have lost it there.
Yes. Which for the other side?
I'm filing an affidavit.
Are you
compliant?
compliant?
They've taken a decision to appoint them because posts have to be created. Can you see annexure A/1 page 5? On 23/8/2024, the SLPs were dismissed. On 25/9/2024, we have written to the government for creation of 63 posts. And accordingly, kindly see page 7.
Yes. Page
Also, the 63 petitioners involving all the.
No, page 7 of what?
7 of that affidavit. Affidavit filed given just now.
Just now we have given. So have you served a copy?
Yes, just now, sir.
So you deal with it. Now they are taking steps.
Already taken. They have just now, sir.
All right.
I will reply.
Further so-called affidavit has been filed on behalf of the opposite parties to make out a case that after dismissal of the SLP, steps are being taken to carry out the court's order, violation of which has been released in the present contempt application. So, plus this matter, a copy of this said affidavit. The reply has been served on London Council for the petitioner today itself. Stop. List this matter on 4 weeks.
107.
So as principal and counsel for the petitioner to consider the said so-called, right? Yes,
On 40th December.
on 20th. No, after 4 weeks. It did come after holidays. In the meanwhile, because they have just started the process.
In this case, government has clearly filed affidavit before Honorable Single Judge that they have no role, and on the basis of the affidavit, Honorable Single Judge has passed order. The state university. Let's suppose that.
See, there are two things. There is an order for regularization. Regularization can always be done against a sanction post.
Yeah.
That order was challenged. That order has been affirmed by Supreme Court. Not affirmed, the SLP has been dismissed. Now, still the question is that if person has to be, service is to be regularized, that is to be done against a sanction post.
There is a sanction
Just
post.
a minute, against a sanction post. If the post is not sanctioned, they cannot comply with the order. They cannot, and we cannot do something which is impossible. So if the posts are to be sanctioned, that will take time. The state government will have to sanction the posts.
In Annex 4 of the petition.
All right, we will see that. So you should also keep this in mind, that the courts cannot do something which is impossible. So,
That is a sanction.
yes.
Almost 300.
We will see.
Item 107.
Your Lordship, last occasion, last week, Your Lordship, this had come up and I had sought time, 3 weeks time, Your Lordship, for compliance. And Your Lordship has granted, but it has come again. I've already intimated the authorities, Your Lordship, and I have also apprised them of the intent of this court, Your Lordship, for compliance. So 3 weeks time may be given, Your Lordship, for full compliance with the order.
Only one chance. I just want to bring before Your Lordship the action of the opposite parties. The order was passed this Honorable Court on 15/2/23 on the basis of learned tribunal's order, State Administrative Tribunal's order. But after 5 years, they filed that tribunal's order in writ petition. Well, this is the writ petition's order, and thereafter they approach Honorable Apex Court. After 5 years, my lord, only the intention to harass the petition. This is the only submission.
Yes. 3 weeks time, Your Lordship. I've already intimated the authorities also, Monday.
No orders I'm not required to have. This is seeking adjournment, I'm just granting that. Can't do anything.
Only before vacation, only one date may be fixed so that they can got back that job, my lord.
As
Out of service, my lord.
requested by AGA, is this matter on 20th?
Yes, sir.
20th, how many cases can be taken? 20th of December is last day. Your bar association may resolve something. Don't know. Let us try.
Item 108.
May with the mercy. My lord, last occasion, government has given a big time, my lord, on dated 4/10/2024.
Complied with Your Lordship.
So it's enabled and AGA to seek instructions. Files over reply.
Well, till today he has not fully completed, only
Yeah,
at 75.
in the meanwhile.
My lord.
Yes.
The order was for representation disposal, Your Lordship.
Huh?
To consider his representation, Your Lordship. And after we have considered his representation on 28/6/2024, Your Lordship. That has been considered, Your Lordship. And Your Lordship, he has been, as per government rule, the subsequent increments have already been allowed.
Only 75,000 something. I
you
will
can
only,
challenge
I have nothing. But I am
working since 1991.
See, liberty can be, nothing can be decided here. Liberty is there.
My lord, partly payment, my lord, the petitioner retired since 2021 November. Till today, he has not received any pension benefit. It's a class 4 employee suffering from so many diseases.
So,
Partly payment 75,000 only.
when did you file that petition?
My lord, I have filed disposed by law 1/5/2023 writ petition.
25/2023.
My lord.
What order did you get? What order did you get?
Just I have taken instruction 75 something.
No. What was the order passed by this court?
1/5/2023.
What order was passed?
My lord, page 9 may kindly see, my lord.
What is there in the order?
Admission with the direction to the Child Development Project Officer, ICDS project, Rajkanika, Kendrapada, opposite party number 4, to consider the representation of the petitioner dated 27/3/2023 under Annex 10, in accordance with law within a period of 6 weeks from the production.
So whether that has
Last paragraph.
read it. Read, you read.
My lord, page 11, para 7, my lord.
Yes.
It is further directed that in the event it is found that the claim of the petitioner is lawfully due and admissible, the opposite party for shall sanction and disperse the amount in favor of the petitioner within the aforesaid time stipulated.
So it has been found admissible.
Yes, Your
My
Lord.
lord, class 4 employee.
It-
Regularized
Just a minute.
91.
Just a minute. Whether it has been found admissible. Madam,
Yes, Your Lordship, it has been found.
pay it.
As per government rule, the subsequent increments allowed, area bill will be prepared in the HRMS portal and disbursed in due course.
When? When was this decision?
8 weeks time. We will.
How much? 8 weeks?
8 weeks. I've
Oh.
received this instruction, Your Lordship. Maybe.
All right. Let's this matter on. 2 weeks. We'll stop. In the 2 weeks, it appears that the petitioner's representation has been considered by the opposite parties in light of this court's order and has been found entitled to certain claims. So stop. This is clear. Let AGA seek instructions as to whether the amount which the petitioner has been found entitled to has been paid to him or not.
109.
Non-complex.
Under 9, Your Lordship, and SLP number 2799 of 2024 is pending.
No, my lord, that SLP, the present petitioners SLP has been dismissed on 14/8/2024, and that has annexed into a flag B.
Yes, it has been dismissed.
I seek instructions.
4 weeks. Time to file so-called as requested by AGA. Does this matter on also as to so and so or filing a so-called reply?
110.
Lordship, may grant me further 2 weeks time, Your Lordship. The Tahsildar has given me some instructions which needs to be clarified, Your Lordship, because
As requested by AGA, does this matter on 2 weeks? Yes.
The matter was last listed on 5th of April 23. Prior to that also, my state also taken time for compliance with the.
Let us see.
In the meantime, there was a waterlog and all. People, petitioners and the villagers met the Tahsildar. Tahsildar is saying that you people, the petitioners also cooperate the how. Yeah, my lord.
We'll see.
This is six, perhaps six police protection or therefore may find your
6.
the Tahsildar may seek police protection or therefore not able to,
I'll see later.
since it is a 2002 matter.
Next.
111.
I need some time to find it.
Yes.
Last occasion, 2 to 3 occasion already my lord was directed to. As a last answer.
This is last.
By way of last.
Your Lordship, there is instruction on the land status, and there is further, the Tahsildar has written to the collector for further information because there is a part of a plot which is not recorded in the name of the petitioner. Lordship, for further direction, instructions the Tahsildar had written to the collector, Your Lordship, I'll see 2 weeks time.
Yes.
Item 112.
There are 3 applications, 2 writ application and 1 is writ appeal matter. But I mean, this is arising out of a arbitration award matter. And the award passed by the commercial court has been stayed by this honorable court in the execution case, and the interim order was challenged in a writ appeal matter. So
No,
writ
why? Just a minute. This is item number
112.
112 is writ petition.
2 writ petition, 1 writ appeal matter. There are
Writ
3
appeal?
items, ma'am.
Huh? Oh, writ appeal can be listed.
Because the honorable single judge is concerned with the opposite party counsel, that is why my
114. In 112.
Yes. 112. That's all.
Division bench. It will go before the division
Yes.
bench.
Not unless and until the writ appeal part.
No, that will go before the.
My
That is wrongly made.
that I am what I am saying. Also taken up any day 2 weeks after, 10 days after.
Yes.
No. No objection. I'm for the opposite.
No, you cannot.
I'm for the opposite party appearing on behalf of Mr.
No, but let me understand this WPC is against which order?
The WPC matter, what happened here, original and award was passed by the arbitrator. That the railway has filed a 34 application before the commercial court. Commercial court dismissed the application, 34 application. We prefer the 37 application before the district judge. While the district judge, the appeal is pending before the 37 application pending before the district judge, commercial court entered the execution case and passed the directed to disburse the 18 crore rupees on the basis of a memo. That is under challenge in the writ application because the district judge inclined to enter hear the matter since the original award was passed by his father. He referred this matter to this honorable court. This may be transferred to some other court. So while this application is pending, commercial court is taking steps to release the entire award amount when 37 application. That is under challenge in the writ application. Interim order was passed. Against the interim order, the opposite party has filed a writ appeal, and the interim order passed by honorable single judge has been stayed in writ appeal. So all these are connected to each other unless and until the writ appeal will have the entire 2 writ application, 1 writ appeal is pending. Arising out of same award. Must have taken up 10 days after before the division bench, it can be disposed of. Because in the meanwhile, on the basis of
why should I take up these matters? These matters should be heard by a single bench. I should not take up. These are 2 different
yes, only writ appeal can be taken.
List. WA number 2/2024 before appropriate division bench. Before division bench. So stop. Next, list these matters on 2 weeks before appropriate bench after obtaining necessary orders from the Chief Justice. Yes.
Item 113.
May please. This is the second round of contempt filed by the petitioner, Miller.
I don't know. I know only one round. Yes.
The petitioner is a widow, Miller. Her husband was a government servant, but till today she has not got the family pension and gratuity and other things, Miller. My lord, at clause 2 or
Yes.
6.2 of the orders, this
3 weeks time.
3 weeks.
no, my lord, because already 9 years have passed. Several times they have harassing the petitioner, a widow lady of 60 years, my lord. My lord, your lordship may kindly direct that let the opposite party number 1 be personally present before this honorable court. My lord, the petitioner is very much agreed. But lady, my lord, 60 years old lady, my lord, not getting his family pension, nor his gratuity and other service benefit and arrear benefit. Let your lordship may kindly, I pray, my lord, with the folded hands, your lordship may kindly direct the opposite party to be present before this honorable court. She is running from Salepur to Bhubaneswar Secretariat, my lord, in each month, holding the feet of so many officers, but nobody is hearing him because she is poor, my lord. Today also she has come to the High Court and declared before the court, my lord. I said that what can I do? The Honorable Chief Justice will hear you.
Honorable Chief Justice is ruleless.
My lord. My lord, your lordship may kindly, it is most important, my lord. Your lordship may kindly save a family, my lord. I am not submitting for my own benefit, my lord. My lord, for the sake of humanity, my lord.
Seek instructions. This matter.
My lord, taku personally appear karagal. The opposite party number 1 should appear in person. Why she has delayed the payment? This is the honorable court's order. This is the second time contempt. She is not caring.
This matter on 1 week within first 10 cases. So, in the meanwhile, an AGA shall be required to seek instructions as regards stage of the compliance of this court's order, violation of which has been alleged in the contempt application. Yes.
Item 114.
My lord, the matter will be taken up for
1 week.
positively, my lord.
The 14 years complied.
If this matter is not, law is required to be done, which is exhibited from the very communication made by the government itself. Here is a case where the petitioner claims the retrieval benefits even if he has retired from service from in the year 2022, till today the pay has not been fixed. And surprisingly, you also may kindly see.
No, what is the order? Let me see.
But the order is for revising it, you also kindly come to running page 12. If you lordship, before going to that on running page 12, if you lordship wants to kindly come to running page 10, the prayer made by the petitioner has been quoted by the honorable court.
No, what is the order?
Order, you also kindly running page 12. Further in the event, after 2 lines.
Yes.
Further in the event, the authorities have come to a conclusion that the petitioner is entitled to the revised pay, then his pay be fixed as per the rules governing the field, and accordingly, all arrears as well as pensionary benefits be calculated as well as other service benefits, including the salary, be fixed and be paid to the petitioner within 6 weeks from the date of taking such decision.
Yes.
And though they have done some, they have proceeded a lot. They have proceeded in that regard for full compliance, but till today the matter has not been complied. After this affidavit has been filed, compliance affidavit, so-called compliance affidavit, this is the communication which clearly proves that the entire period has not yet been decided. Then how they have arrived at the figure? My lord, may kindly see what has happened, my lord. The period of absence, that is for the period which the honorable court has quoted in the order.
See, I have my own difficulty.
Sorry.
I have for the reason that all the submissions which you are making here,
yes, ma'am,
that were not adjudicated upon by the court and single judge.
Ma'am.
And single judge disposed of the writ petition with a direction to them to consider and decide. And if you are found entitled to pay,
Well, they have found out. They have found out that I am entitled, but they are now shifting the burden to somebody else. That is what I was bringing to lordship's notice. Now they say, I will do only after the PR department does. That means after getting the nod from the Panchayat Raj department, the payment will be made. That is what they are communicating.
Yes.
But in effect, my lord, they don't.
In effect, everything had your case been decided in the writ proceeding, everything could have been clear. But now they are saying that it will be done by.
Instead of shifting the buck on the
They are not shifting the buck.
You also kindly see, they themselves have said, I have brought by way of an objection.
Mr. The question, that is not the question. The question is, have they committed an offense?
No.
If they have not committed an offense, then how can I proceed?
Well, it's a case, my lord, whether they have complied with. Now they say we have complied. Your lordship may not penalize them. But when they are saying on affidavit that we have complied the order, our humble submission before lordship says, your lordship may kindly see whether this statement made by them is truthful enough or not.
Right.
They have not complied with. Let them take time to comply instead of shifting the burden. By saying the PR department, after getting the nod from the PR department, it will be done.
When did you file the writ contempt application? When did you file the contempt application?
This is the second round of contempt.
Just a minute. When did you file the first contempt application?
First contempt was filed on 9, filed on 16/10/2023.
23. And when was that disposed of?
That was disposed of on 19/10/2023, granting them further time.
Just a minute. 19/10/2020. When did you file the second contempt application?
Filed the second contempt on 18/1/2024.
And when was the matter taken up first?
My lord, the matter was taken up by the the Honorable Single Judge on 9/2/2024.
Thereafter
on 13 days. On 13 days.
13 days. Just a minute. Why I'm asking you to mention.
Right.
So your contempt petitions were taken up for 18 days. All right, and still not complied with. When did you file the writ petition?
Well, I filed the writ petition. The writ petition on sorry. Just I filed the writ petition on 11th May 2023.
On 11th May 2023. When was that disposed of?
It was
when was that taken up first?
It was disposed of on the first date itself.
On the first day. So you file a writ petition in May 2023 and that is disposed of in one hearing.
Right.
And 13 hearings, more than 18 hearings in contempt petition. And you want me to decide your merit.
No, not on merit.
This?
Not on merit. I'm not saying
there is no question of the thing which could have been adjudicated upon. We cannot. In contempt proceeding, I cannot.
So you'll also grant liberty to the prisoner to ourselves.
Counsel for this is not, just think of, and you should realize this, that contempt petition, writ petition, 1 day, contempt petition, 18 days. And then it is the stand of the opposite parties that this court's order, violation of which has been alleged in the present contempt application, has been complied with in as much as the petitioner's case has been considered and he has been found entitled to a revised pay. So stop. And counsel appearing on behalf of the petitioner has, however, submitted that despite the fact that the petitioner has been found entitled to, the arrears of salary and consequential pensionary benefits have not been paid to him. Coercive has disputed the calculation also. No.
Since they have not done, they are saying we are awaiting the action of the other side.
Next, and counsel has submitted that the compliance of the order is getting unnecessarily delayed on the ground that that final approval is to be made by which department?
Panchayat Raj Department.
Panchayat Raj Department. So stop. How much time will that take, madam?
Actually, 4 weeks time may be granted to Lordship. Because there was a period of absence, they have sanctioned everything and moved to the district treasury for payment. Only there are 2 periods of, one was the period of suspension and the period of absence that they have said that they will see the sanction of the departments and then.
List this matter on 2 weeks. Stop. In the meanwhile, the opposite parties are required to ensure that whatever is admissible to the petitioner is fed to him. Stop. It is made clear that this court shall not entertain any dispute on the quantum of payment, common quantum of the petitioner's entitlement. Do it within 2 weeks. If they have been found entitled to, this will be paid.
115.
Only my register was
Regis.
115.
Complied with.
Complied.
116.
Hi, please. I am in virtual mode. Your Lordship, after order dated 29/20/24 of your Lordship, they have just started the process. I pray only 2 weeks time. Next date is fixed to 8th. Direction was to entertain my application for permanent lease and dispose of within 2 months. But
Where is the order?
The order is, your Lordship, after hearing, passed the order dated 29/20/24. Twice your Lordship directed them. 29/20/24, kindly have a glance to your Lordship's order in the present contempt proceeding. 20th September and 4th October. Both the orders your Lordship can see. Mr. Kuntia, my land friend, was there.
Yes.
Lordship, what we have received the instruction from the Tahsildar, the main annexure 3, the document that was submitted by the petitioner that annexure.
They have started process.
Annexure 3, your Lordship. What is the Tahsildar says that is not was not there in the compilation of the documents that were presented by the petitioner for him.
Annexure 3 to what?
To the writ petition, your Lordship. Because the
contempt.
High Court had passed an order on 5/7/2023 with a direction to the Tahsildar to dispose of the annexure 3, your Lordship.
Where is annexure 3?
That has not been.
Yes, Mr. Mishra, where is annexure 3?
Annexure 2, your Lordship kindly see, after the order was passed.
Mr. Your representation was to be disposed of.
My
Your representation could be disposed of only if the representation was there in the office.
It is actually, my land friend perhaps not properly instructed. My instruction is they have started pursuant to Annexure 2. They have issued notice and my client has.
Mr. Mishra, whether Annexure 3 was there in the records of the Tahsildar or not?
Yes, it is there. They have acted upon on this. After your Lordship's order, that is my submission. Your Lordship can take note of it. After your Lordship's order, they have issued notice to my client. My client has appeared, submitted all the documents, and next date is 8th.
On next week. With
8th, my lord, 8th.
Just a minute. With the records of WPC number so and so.
Okay.
In the meanwhile, and AGA shall also seek instruction as to whether Annexure 3 to the writ application, which was required to be disposed of by the Tahsildar, was in fact filed before filing of the writ petition before the Tahsildar or not.
Okay.
117.
Not comply the order
Before
dated 25/11.
Yes.
127.
Item
117.
Lordship, writ appeal number 1041 of 2021 is pending.
Yes, Lord. Kindly see, my Lord. The writ petition order was passed in disposal of 25/11/2022. Thereafter, I have filed a contempt petition, my Lord. The contempt petition disposal on 14/11/2023, my Lord. Thereafter, my Lord, the writ appeal was filed, my Lord, 2/5/2024, my Lord. This is the matter regarding provisional pension, my Lord. The petitioner already retired from service, my Lord. He is not getting any provisional pension. Now he is going to financial crisis, my Lord.
Only the motto is, my lord, the rate of appeal was filed, the harass the petitioner.
Why?
The after 2 years, my lord.
No, is there any enmity between you and
No, my lord, that is not intention, my lord. Only the, my lord, the contempt petition disposed of on 14/11/20.
No, what, why do they want to harass you?
My lord, 60
Any
years old.
friendship or any enmity or?
After retirement, he is not getting any provisional pension, my lord.
No, why? You are saying harassing.
After
Why
2
should
years, my lord, after 3 months, my lord,
What is the stage of writ appeal?
nothing, my lord, only filed.
Filed on 4/5/2024, it is still pending.
Not initiate anything, the.
And you are, what stops you from making payment of provisional pension? We will, let me see.
Last occasion also, my lord, take instruction for this regard.
Find out.
Pension, my lord.
Next week. As requested by London AGS. Yes.
Item 118.
600, we have complied, but after compliance led, they have filed, compliance had filed. After that, they have filed an objection.
The objection is not in record. This is not.
The Russia's passed an order.
They have.
Russia passed an order directing to dispose of their case as per the judgment of the Honorable Supreme Court. That is higher pension in provisional matter. So they have to give joint option. Joint option they have not exercised. They have written, but that was incomplete. So we have issued a letter that you comply the matters. In view of that, we have already complied their grievances.
We have
and I have filed the compliance.
I have complied the 2 days after. The letter issued on 10th of May.
Let me see the order.
The operating portion is page 14, running page 14. Paragraph 8.
Yes.
In view of the aforesaid submission made by the learned counsel for the respective parties, and further taking into consideration the judgment of the Honorable Supreme Court referred to herein above, and the circular issued by the Government of India dated so and so, this court deems it proper to dispose of the writ petition at the stage of admission by remitting back the matter to the opposite party number 3 and 4. The opposite party number 3 and 4 are further directed to consider the matter in the light of the Honorable Supreme Court's judgment dated so and so, as well as the circular dated so and so, and take a decision in the matter within a period of 8 weeks. Thereafter, my lord, we have submitted the joint option for in view of the circular and the Honorable Appellate Court judgment. They have said this application and the online application, there is some discrepancy, you rectify it. We rectified it. Thereafter, their officer went to our establishment and inspect all the documents. They issued a letter on 10/5/2024 saying that you further resubmit the applications. My lord, the 2 days after we resubmitted the applications on 13/5. Till date, my lord, no decision has been taken. When I filed my objection, the next day the officer went to our establishment and inspect everything and said it's okay. But now my learned senior, I pray before your lordship, may take instruction what is the stage of our application.
Lordship can turn to page 9 of.
No, whether in the light of this court's order you have taken it in decision.
Yes.
Where is that decision?
That are page 9 in the complaints order in there. Page 9 of my focus below. Last parameter. Page 9. Last para. This is the order we have passed in that. 9. And whereas they got in that.
Yes, it has been
And
disposed of.
My lord, they have said that on 10th of this order passed, 10/5. My lord, they are saying since the online resubmission of option is still awaited from the establishment.
So that is different. The order, they have complied with the order and thereafter they are taking steps.
Taking the steps. My lord, the order was that they should take a decision.
That decision that they have taken.
No, my lord, whether we are entitled as per the Supreme Court judgment or not, that has not been. My lord, it was passed on 10th of May. On 13th of May, we resubmitted.
And
On 13th of May,
Right, you can challenge this.
my lord, there is no ground to challenge this, my lord, because, my lord, we have resubmitted on 13th.
What?
Resubmitted the option form. That is in my objection I have
come
given.
to and whereas the previous paragraph.
My lord. The second paragraph, second page 9, second, and whereas on receipt of the joint application digitally, it was scrutinized by the office and the descriptions were communicated to the employer with a direction.
And whereas the joint option by members is required to be regulated as per the judgment of Supreme Court.
My lord.
So and so.
My lord.
Ensure compliance of each point.
My lord.
So it is not that the decision has not been taken. They have, that was your representation that has been disposed of.
My lord, they have directed for resubmit. We resubmitted it. Thereafter, they should take a decision whether we are entitled or not.
No.
My lord, your lordship may kindly see we resubmitted on 13th. The next day, they have issued on 10th of May. On 13th of May, we resubmitted. My lord, what is the stage of our application? Whether we are entitled or not. If we are not entitled, then we definitely will challenge our. My lord, this order says you resubmitted. We resubmitted. What is the final decision? They have not taken any final decision.
After the order is passed, they have submitted the forms.
That order may be illegal. The petitioner has alleged disobedience of an order of this court dated 25/1/2000.
That's 10-5, they are passing order.
Passed in WPC number 4782 of 2022, operative portion of which reads as under. So stop. A compliance affidavit has been filed stating that in compliance of the aforesaid order of this court, the petitioner's representation has been disposed of. Which paragraph?
This,
Which page?
Page 9.
Representation has been disposed of in the following terms. Last, and whereas joint option filed by so and so. So and so, in view of the representation disposed of. Next, current counsel appearing on behalf of the petitioner has submitted that one petitioner has submitted that the said disposal is not in conformity with this court's order dated 25/1/2023, in as much as there is no opinion recorded by the competent authority as to whether the petitioner is entitled for the benefits in terms of the Supreme Court's order dated 4/11/2022. Stop. In fact, the opposite parties are still in the process of taking a decision on this said point. Stop. Next. After having heard learned counsel for the petitioner and learned counsel for opposite parties, I am of the view that there was a direction by this court to dispose of petitioner's representation in the light of the Supreme Court's order. Stop. Judgment dated 4/11/2022. Stop. The said judgment has been taken into account while disposing of the petitioner's representation, as has been noted above. Stop. It cannot be said that there has been any intentional inaction or deliberate disobedience of this court's order on the part of the opposite parties. Stop. I am not inclined to proceed further in the present contempt matter. Stop. Next. The petitioner shall, however, be at liberty to pursue his case before appropriate authority / forum in accordance with law.
On the court. So it is the same order.
119.
119, my lord, I'm appealing to VC.
SLP.
My lord, this is the second contempt application.
SLP is pending, madam.
Yes.
SLP is pending. Yes. Next.
120.
May I please your lordship? The non-compliance of the order dated 17/10/2023. The lordship, as per your lordship's order dated 27/9/2024 in contempt, the opposite parties not filed any show cause or not complied the.
Yes.
That's, we have complied the order, and the show cause is ready, my lord, we are filing it, it's been compliant.
They have been compliant, then disposing it off. What was the order?
The order was to,
It's-
the order was to supply him a copy of the final assessment order, so as to enable them to file an appeal under statutory appeal within a particular time. We have supplied them, they have filed the appeal. Upon filing of the appeal, we were supposed to restore the electricity supply. We have restored the electricity supply in March. The contempt was filed in April. We have both supplied the copy as well as prior to contempt, we have complied.
It appears based on submissions which have been advanced on behalf of the opposite parties that this court's order has been complied with, in as much as the order of assessment has been made available to the.
Your lordship, they are not supply me the restore my supply in connection. I take new connection. As per lordship's orders, they not comply.
Filing the reply, we have, you'll also may recall the submission, we have complied. We have provided the copy.
2 weeks time is allowed for the opposite party. Following counsel for the opposite parties to file. So cause reply. That's this case 2 weeks.